Welcome to the 2023 Current Issues Workers' Compensation Conference, brought to you by the law offices of Richard L. Montalbo and sponsored by Apple, Innovation for Your World, LexisNexis, not just more content, but more efficient research tools, Matrix Document Imaging, assisting both the defense and applicant bar, National Document Imaging, the Insurance Defense Subpoenaing and Document Company, Arcadia and John Pinto, your structure financial settlement professional, ExamWorks, provider of workers' compensation evaluations, MedLink, professional medical legal evaluators, and Amitros, savings and support for injured workers. This year's conference was with both an in-person audience and again virtual, webcasted from the historic and elegant Vizcaya, located in downtown Sacramento on March 17, 2023. Before we begin, you may wish to download the conference materials, which are available without charge at montalbolaw.com. Should you be interested in CEB, MCLE or QME credit, please contact the law offices of Richard L. Montalbo for terms and to receive your certificate of completion. The opinions expressed herein are the opinions, legal interpretation and analysis of the presenters. The viewer of this video presentation is encouraged to review in its entirety the case decision or statute which is being discussed. The 2023 Current Issues Workers' Compensation Conference involved two separate panels and sessions, each of which are just over 2 hours, with another hour of self-study that qualifies for 5 hours of CEB, MCLE or QME educational credits. The first session will be 2023 Case Law Update, with the focus on case decision originating with the WCAB. The areas of emphasis for this year's conference will include apportionment, permanent disability, injury AOE, COE, and medical legal procedures. The panelists include Mr. Jason Marcus, retired Judge Dudley Phoenix, and Richard Jacobs Myers. The moderator for this session will be Mr. Richard Montalbo. Let's begin by introducing each of this year's panelists. The first member is Mr. Jason Marcus. Mr. Marcus attended California State University, Sacramento, and upon graduating, attended University of the Pacific, McGeorge School of Law, graduating in 2008. Mr. Marcus is a partner in the firm of Marcus, Regalado & Marcus, located in Sacramento, California. He is a member and past president, secretary of the executive board, as well as being on the board of directors since September 2010 of the California Applicants Attorneys Association. Mr. Marcus is also a workers' compensation certified specialist and exclusively represents injured workers. Joining Mr. Marcus is retired Judge Mr. Dudley Phoenix. Mr. Phoenix is a graduate of UC Davis Law School and was a workers' compensation judge with the Sacramento WCAB for over 2 decades. He is currently in private practice which focuses on representing police officers and firefighters in Sacramento. Mr. Phoenix was recognized in 2006 as one of Sacramento's best lawyers by Sacramento Magazine and continues to be a leading voice in the state of California in the field of workers' compensation law. Next, Mr. Jacobs Myers is perhaps the leading authority in the field of California workers' compensation law. Mr. Jacobs Myers attended St. Mary's College 1968 to 1972 and earned his law degree from University of Santa Clara School of Law, JD 1975, where he graduated cum laude. He is currently employed with Shaw, Jacobs Meyer, Crane, Claffey and Nix, representing defendants in workers' compensation litigation. Rounding out this panel as moderator is Mr. Richard Montalbo. Mr. Montalbo holds degrees in business economics and computer science and received his law degree from the University of the Pacific McGeorge School of Law, where he is currently an adjunct professor. He is also the architect behind Current Issues Workers' Compensation Conferences and a frequent presenter at various legal conferences and symposiums throughout the state of California. Mr. Montalbo is also the app developer and designer of the CompCalc, the industry's only smart device workers' compensation rating and indemnity app. He is also the author and editor of the Work Comp Index, a topical guide to the law of California workers' compensation. Let's join our panel already in session.
I see a lot of people back at the food service, and I think we're all rusty, aren't we? This is the first time back in 3 years, and I see from the name tags back there that some people are tardy. I say that what we do when they come in is we announce them individually. No, I'm not going to do that. The food service is available out there. Nobody's going to be offended on this panel by you going back there during the presentation and either getting another latte or helping yourself to the food.
Thanks, I appreciate that, Rich.
You can't walk out of here, Jake. We're not going to let you. Let me start by welcoming everyone to the 28th Annual Current Issues Workers' Compensation Conference. You know, it's 3 decades that this conference has been ongoing. We almost ended it 2 years ago, the second year of the pandemic. And just by way of a show of hands, aren't we all? And I'm just going to say this about myself. I'm boosted, I'm vaccinated, and I was fortunate enough not to catch it once, but twice. I tested twice for COVID. It really wasn't that difficult for me. I think I was fortunate, I was lucky, others were not. But I will say this, that I think all of us are ready to move on to the extent that it's safe and prudent, but I think we're all ready to move on. And it's nice to see everybody here. I can only say this, that I think everybody, I don't like the way that things have changed at the board. I don't like the way that we've all gone to Zoom video. I think that people treat each other differently over a phone call, court call, Zoom video, and sometimes I shake my head with what I hear going on. And that's one aspect that the pandemic has had on the practice of California workers' compensation that I don't much care for. Anyway, let's go ahead and start with, first of all, I want to make sure everybody's downloaded the materials. If you go to montarbolaw.com, now I've put about between 350 and 400 hours in these materials. What you're going to see is a lot of cross-references, a lot of sites, a lot of information separate and apart within each case, so that you actually are able to use this as really a research tool, hopefully long after the conference is concluded. So if you go to montarbolaw.com, there's a button there, just hit it and you can download the materials. Now, let me also address why, I know why everybody's here. Everybody's here because of great speakers and great materials. Not so much. Great food. It's good food, but not so much. We have a whole lot of latte all day. Great coffee. Not so much. Let's get to the fun part. And that's the whole thing about this conference. What I've done, let me tell you what the philosophy of the conference has been. I wanted to put a conference together over the years that allows the defendants and the applicants to come to one place and have a considered and reasoned discussion that's always respectful. And during that 28-year history, I can only think of one occasion where I had a speaker that didn't meet that standard. I select both the sponsors, and you should know this, the sponsors that sponsor this and help us out with the cost of all the gifts, all the prizes, are by invitation only. What you don't see at my conference are the private investigators. You don't see some of the doctors' groups, and I'm not going to focus on any of them, but so it's only by invitation. And during the course of the year, people approach me and want to be a sponsor. And I'm polite. There's no reason to be rude to anybody, but I select the sponsors. Now, because of these sponsors, we have great gifts and prizes to give out at the end. And I know what everybody's hoping to win. What is everybody hoping to win? I know everybody wants a copy of this book, and we're going to remain seated, don't charge the podium. We'll be giving 2 of these away, but we're giving away some awesome prizes. Apple's come through for us, as well as all the sponsors. I next want to discuss the CompCalc. If you're not using the CompCalc, you should be using the CompCalc. That's not my opinion, that's the opinion out there. About 3 years ago, I met Tom Brown, and Tom, who owns Matrix Document Imaging, came to me and he said, we'd like to license the CompCalc. At the time, I had license agreements on the CompCalc with other vendors, other photocopying and subpoenaing services, so I couldn't do it. I wasn't going to, for a check, dishonor my commitments to others. But as those commitments ended, Tom and I discussed it. Now, this is what I would say about vendors. We all have our favorites, and you can see by the sponsor list, who I respect. But I will say this, that everything's fee schedule now. What differentiates the doctors and the photocopying and subpoenaing services is service. So Tom and I talked about it, and what I liked about what he had to say was his commitment to actually adding additional features. And there's a feature in the CompCalc that it's very expensive to implement, and we've implemented it in the iOS, the iPhone version, and also in the Droid version. And that is to include the AMA guide tables and methods for rating the WPI. So here's the way that it works. I'm sure everybody's aware of this, but let me go through this. On a rating string, the CompCalc does it all. It does multiple rating strings. It does what we call bidirectional calculations, so you don't have to go first, second, third on your inputs. You can just change one, and it automatically recalculates everything. It calculates your indemnity, never above the max or below the min, given the date of injury, given the average weekly wage. It just does a lot of features. But when you have a rating string, you're going to put in the part of body, and the next thing is the whole person impairment. Generally, that's provided by the doctor. And if you want to check that whole person impairment, you have to what? Pull out the AMA guides. So what I envisioned was that we would actually implement a way and we now have 24 of the methods for range of motion. You can put those variables in to check to see whether or not the doctor properly calculated it. And that's something that Tom and I discussed, and we do have it in the iOS version right now. Now, the Matrix, and a lot of people have asked me, Rich, are you going to still maintain your involvement? I am. I'm developing and I'm also testing, and that's going to remain for the foreseeable future. But if you download today, it's free, the Matrix CompCalc on your iPhones and your Droid devices is completely free. All you have to do is go to the Apple Store, the Google Play, put in my name or Matrix CompCalc, it'll pop up, and it's free today. So I would, now why do you want to update? Why do you want to transition? Because the other versions are out of contract, they're not being supported, and you're not going to get the current indemnity charts, indemnity figures, and you won't have the additional features. So be aware of that. The last thing I would say is, like I indicated, the vendors that are sponsors of this are by invitation only, and those are vendors that I think, to the extent that I have any influence on anybody, consider them. I think it's a wise choice. Okay, the brunch is going to remain open through the first break. Then that'll close down. We'll have our second panel. That'll conclude around 1 o'clock. Then we're going to have the fun part, which is the raffle, drawing, and the wine tasting with hors d'oeuvre pairing. So everybody should have a fun time with that. Let's talk about the MCLE specialization QME certification. Whether you're viewing this online, and let me also go back to the raffle. We've got 350 people online, and but I think that if you get out of bed and you come down here, you ought to be rewarded. So how are we going to handle the raffle? I thought about this. I sent emails out. I hope everybody's not upset about this. Nobody here is going to be upset. I can guarantee that. But all the prizes are going to be raffled, with the exception of one, to the in-person audience. But you have to be here. So that means you have to stay the whole day to see if you win, right? The one prize that will be available to everyone, so we have two raffle pots, if you will. One is everybody online and everybody that's here, and that's only for the Mac Pro computer. See, this is the important stuff. All of a sudden, everybody's looking at me so intensely. Then all the other items will be just for the audience that's here. And you know what? I know that was a rule change a few weeks back, but it just made sense to me to handle it that way. Okay, so download the materials. We've talked about the CompCalc. We've talked about the sponsors. We're going to be sampling 3 great wines. They are Melka Winery, Old Winery Road, one of my favorites, and then Titan Family Estates. So these are really, really nice wines, and they've set up a really nice venue out there. Although we're probably going to break for 15 minutes. Everybody can get their glass of wine, then we'll come back in here for the drawing, because we'll do it here in this location. Okay, back to the MCLE specialization. We have 2 panels of about 2 hours apiece. That's 4 hours. What I did was I petitioned the State Bar and also the DWC because you'll see the materials, they're voluminous. This is a year's work on my part, not only for my book, but also for this conference. And I petitioned for an hour of self-study. So you'll actually get 5 hours. Now, to get that hour of self-study, let me tell you what you have to do. You have to actually sign a declaration and submit that declaration, okay? So sign that declaration, submit that declaration to us, and you'll get 5 hours, whereas we're just gonna, the live in-person's gonna be just 4 hours. Okay, we are going to, at this point, let me introduce our panelists. And you know what I decided to do? Everybody knows the speakers on this panel. They've spoken here before, and they speak up and down the state. You know, I'm so fortunate. Over the past 28 years, the alumni for this conference is incredible. I've had Commissioner Cuneo, Jim Cuneo spoke a couple of years. Marguerite Sweeney, another commissioner, spoke 3 years. We've had Skip Tesher, Bill Herreras, Joe Capurro, who's a current commissioner. He spoke here year after year. So when I select speakers, I make sure that they have the gravitas and the knowledge and the competency, and a certain presentation too, because it's difficult enough to keep everybody, keep your mind on what's going on. And in large part, because I'm part of this presentation, that's why we have the espresso bar, because I want everybody to be caffeinated and aware of what's going on here. But let me go down the list. What I thought I'd do is, you can read their bio, but let me tell just a couple of stories about everyone. That's always fun, isn't it? And
I'm not sure yet.
they don't know what I'm going to say. I'm always, well, no, I'm not always nice, but usually. Let's start with Jake Jacobsmeyer. The first time I met Jake, I'm with Lachlan Falvaliva Marisi. I have a deposition down in Oakland. He's an applicant attorney. You don't know this story. And I go into Roy Wolfstead. You know Roy.
Yeah.
And I go, Roy, I've got a deposition with an attorney down in Oakland. Do you know him? He goes, who is he? And he goes, I said, it's Jake Jacobsmeyer. He goes, oh. And I go, what? And he goes, it's Jake Jacobsmeyer? And I go, yeah, Richard Jacobsmeyer. Yeah, what the heck? He goes, he's tough. You better be prepared. And let me tell you, at that point, I'm probably a 3-4 year attorney. I think I know more than I don't know enough to know I don't know enough, okay? And so I drive down, and let me tell you, I've got my cannon ready. I'm ready to go to war. I'm going to get my depo. You know, I'm young, I'm spry, and I think I'm quick. Anyway, I walk in, and I sit down in the conference room, and his client's there, the court reporter's set up, and Jake comes in with a big smile on his face. He walks over, he goes, hey, my name's Richard Jacobsmeyer. You can call me Jake. And he reaches out and he shakes my hand. And I'm thinking, okay, this is the calm before the storm. It didn't change the whole time of the deposition. You know, he pushed back on some things, perhaps appropriately, I'm not sure. But that's the first time I met him. Now, Dudley, the first time I met him, we were at the Sacramento board. And we were in one of the rooms. You were an applicant attorney. And I had just had my ass handed to me from a judge. And I'm in there licking my wounds. Let me tell you, sometimes judges can be tough. And I'm in there licking my wounds, and I'm a little pissed, okay? And I talked to Dudley. And he says, well, here's the deal, Rich. Because he's down at that time, he was in Sacramento all the time. He knew the players better than I did. He said, let me tell you about this guy. Don't argue with him. Go ahead and let him know he's right, but tell him why he might be wrong. And what I learned from, and it worked. I went back in, we had to fill out the 5-pagers. He was a lot nicer to me. I won't tell you who the judge is. He's retired. But it went a lot better. The last story is when I met Jason, and I mentioned this to Jason. Jason's father, Mark Marcus, is an applicant attorney of some notoriety, and he has the distinction, and he's held this over my head my entire life, ever since this happened. I had a case that was pulled from another law firm, brought into my office. It was a 100% case. This is a total disability case. But I had one argument. The applicant wasn't permanent and stationary. And I fought tooth and nail for 2 years to keep the applicant on TD. Now, the reason it was pulled from this other firm is this was back during Reiner. There wasn't one, there wasn't two, there wasn't three, there were 4 penalties. Okay? So, and they were paying $20 to $25,000 in medications to this guy. Okay? And so they were every month having to pay all this money, and they were given an attorney's fee, and they were given, I mean, there was a lot of motivation not to resolve that issue. So that case, ultimately, I stipped it at 100%, but I got rid of the penalties. So I mean, there was some motivation on both sides to resolve that. But anyway, that's the only time that's ever happened to me. And I think that's the only time that your father's ever gotten it, because when I met Jason the first time, his father led with that story. So that's how I met these 3. I'm going to start out by kicking this off to Jason. Jason's going to give us what's hot and what's not from the CAW perspective. They just had their winter conference in January. And then we're going to follow up with some penalty issues. These are not in your materials, with Deadly Phoenix, and then we'll start the materials. Okay, go ahead, Jason.
Yeah, thanks, Richard. When he talked about people that didn't do well, I think he was talking about me, right? Is that what? Yeah. But he couldn't find anybody to fill another applicant attorney spot. So, anyways, nice to see all y'all, and it's been a while. This is much better than speaking just to the cameras. Was that last year, the year before we did that? I don't know. The years all blend together, so it's nice to see everybody. So Richard asked me to talk about kind of what is happening at CAW, what our focus is, what our concerns are. You know, we've been hearing rumbles for a couple years that there's going to be some big workers' comp reform. You know, it's been, 10 plus years now since the last reform, and that's kind of historically what happens. We thought something was going to materialize last year. It didn't. We're watching for it, but not sure there's going to be anything this year. You know, so, and obviously, you know, in reforms, we're typically trying to just make sure we don't lose any further benefits or further takeaways from our clients. We don't really have a huge agenda about, you know, massive system-wide reforms, other than, you know, getting rid of UR and IMR, but I appreciate that that's not likely to happen in my lifetime. One issue, though, that we are seeing a lot of litigation on, and we're certainly interested in, is the so I know a lot of people refer to it as KITE, the KITE decision that said, you know, you can add when there's synergy. In that case, it was bilateral hips, and the doctor said that there was a synergistic effect. To me, it's bigger than that, and it's actually a different issue. It's really, is the combined values chart accurate, or is some other combination method more accurate, typically addition? The shorthand is KITE, but I think, to me, that's a little, it's not as clear as I'd like it to be. KITE was synergy. My opinion, and there's some cases that I think have held this, that you don't actually need synergy to have addition. I think it ultimately comes down to the opinion of the medical evaluator, whether a QME or an AME, whether that doctor thinks that it is or is not appropriate to add certain impairments to get to the final result. So that's something we've spent a lot of time talking about. I'm sure most of you have dealt with that or seen some of the cases or seen letters. Those of you on the other side seen letters from myself or other applicant attorneys where we want to ask the doctor about addition. So that's kind of I think the biggest legal issue we're seeing right now. And then yeah, sorry, I saw you moving there.
Yeah, just a quick comment. Is this on? I guess it is. Just a quick comment. This is the way that I look at the whole synergy issue. 2 + 2 = 3 is combined value. 2 + 2 = 4 is kite, aggregation. 2 plus 2 equals 5 is synergy. And we have cases, this is how I've organized it in my book, we have cases on all three of those. So I think there are three separate arguments. So just again, 2 plus 2 equals 3 is combined value, it always reduces. 2 plus 2 equals 4 is kite, that's aggregation. 2 plus 2 equals 5 is really synergy, where you have multiple disabilities that actually increase the overall level of disability, permanent disability.
Yeah. So that's kind of like, you know, an issue that we're kicking around and working on. Legislatively, I know Dudley's got some legislation that's passed he's going to talk about, but things that we would like to see happen, or really, I guess the biggest complaints that we get from our clients, from injured workers, all boils down to medical treatment, and it's kind of two issues. It's access to care, and then it's denials of care. You know, one of the biggest issues we have, at least that I see, and I know it's not unique to me, is being able to find a doctor. You know, I practice primarily in Sacramento. I have a lot of clients with orthopedic injuries who ultimately need a surgical consult, and it can take months and months to find a doctor that's willing to see my client. And generally, that's not an issue of authorization. It's not an issue of the carriers not willing to authorize it. It's an issue of lack of doctors and then the hoops you have to jump through to get into a doctor. And let me be clear, if there's doctors in the room, or orthopedic surgeons in the room specifically, I'm not trying to slight you or offend you or anything like that. The reality is we don't have enough doctors in the system, and so understandably some of those doctors are tight with their schedules or choosy in the cases that they take, but ultimately that all leads to delays where my client is off of work, their injury's getting worse, they're burning their TD, they're calling me constantly saying, what are you doing, what are you doing, what are you doing? You know, I try to lean on the other side. I try to lean on the medical access assistant. But by the way, how many people know what a medical access assistant is or use them on a regular basis? Okay, so speaking to the applicant attorneys.
As I look at that, those were all applicant arms.
Yeah. Look, I'm all about, if I can find a way to have someone else do my work, I'm more than happy to do that. And the labor code provides that carriers must have a medical access assistant to help with getting access to treatment, whether it's finding a doctor or scheduling an appointment. So I use that all the time, right? I mean, I'll look at an MPN and I'll tell my staff, try this doctor, try that doctor. But if we strike out, I'm like, all right, get the MAA involved and have them work on it, right? I mean, why not have somebody else do it? But it's also something that's provided in the labor code. But it's a huge issue for our clients. It's something we're trying to address legislatively, trying to find ways to whether it's entice more doctors into the system or increase access to care. And then, of course, the other issue is just denials, and we can talk ad nauseum about the frustrations with UR and IMR. And I don't have any illusion that we can run a bill that's going to eliminate UR or eliminate or change IMR. But, you know, if you ask me what's on my wish list, it would certainly be making some tweaks to those things. I think that's about all that's going on.
Okay. Dudley's going to, he's got a recent past year enacted labor code dealing with penalties that he was involved in actively, and he's going to give us an overview of that.
Good morning. I too, it's really nice to see everybody and actually do one of these presentations in person. It seems like a long time. So I was approached by the California Professional Firefighters probably a couple of years ago now, and we were talking about what reforms might occur that would benefit firefighters and their membership. And one of the issues that came up was the perceived high denial rates of presumptive claims. And that's sort of my niche, is public safety. So I deal a lot with the presumptions, which are the heart presumptions for, you know, the heart trouble presumption, cancer, hernia. There's a number of presumptions described starting at Labor Code Section 3212. But anyways, the perception was that these presumptive cases were being filed and being denied at a very high frequency. So I looked at my caseload, and I think I had, let's say, 29 presumptive cases at the time. It might have been just cancer cases, I can't recall now, but I think 24 or 25 of those had actually been initially denied. So we then went out to other applicants' firms that did a lot of public safety, and we were getting similar responses as far as really high denial rates. The state of California does not keep track of the denials that are issued in workers' comp claims, at least the 5402 denials, the 90-day denials. So we didn't really have any hard evidence to go off of in addressing this perceived issue. And so we decided that the most effective way to deal with it would be to increase the penalties that are applicable if a denial is deemed to be unreasonable. And that was, so there was a lot of discussion on how exactly we would increase the penalties. As you guys know, the current state and the prior state of 5814 had a 25% penalty or $10,000, whichever was the greater. So if somebody denies a very serious or catastrophic cancer case, they're looking at possibly a $10,000 denial, which just didn't really seem to correlate with what was happening. So after a lot of discussions, that was increased to 50% or $50,000, whichever was greater. So now when there's an unreasonable denial of one of these presumptive cancer cases, the penalty has been increased to $50,000, which hopefully will serve as more of an incentive to conduct more of an investigation before the initial denial goes out. Other things happened as part of this legislation as well. It wasn't just the penalty for presumptive cases. For many of the presumptive cases, the time to investigate the claim was reduced from 90 days down to 75 days. For certain presumptive cases, the aggregate amount of temporary disability that you could receive was expanded from 2 years up to 5 years. This was all contained in Senate Bill 1127. And so I would refer you guys to that for more detailed information. But I think in 16 years, I think since Schwarzenegger passed or signed Senate Bill 899, I think this is really the first positive legislation for an employee group in workers' compensation. So I was really proud of being part of this. The governor did sign it into law. The investigative part of it, the 75 days, is still in 5402. But the penalty provision, which was signed into legislation under 5414, I just learned this morning was actually renumbered by the fine people over at the, I think was it Bender, and these fellows are on their consulting board apparently.
Hold it.
We're
going to defend this. But they're a sponsor, so we want.
Oh, I'm sorry. Well, no, and it makes, and I have to say that there was a lot of.
It's fine.
Well, so the penalty part of it was passed as 5414, and again, as everybody here knows, the penalties are otherwise contained in Labor Code Section 5814, right? And so when this came out as 5414, a lot of people were confused, like, well, if this is an increased penalty, why is it in 5814? So what the publisher says here, and I just learned this morning, it said that it is the publisher's belief that the legislature misnumbered this section and that the section should be numbered 5814.3. So if you look for these increased penalties, you'll find them under 5814. But it again, given my caseload, it has had an impact on many of my cases. I haven't actually litigated a 5414 penalty, but just the fact that it's there, and then you look into Christian and Reiner and some of the penalty cases that allow for multiple penalties. So you're looking at the initial denial, the QME comes in, the case still isn't picked up. You get to 3 or 4 of these penalties, you're looking at $150,000, $200,000 penalty potential. So I have seen it make a difference in some of my cases. So that's about it.
Okay, could I have my labor code back? I don't know why I gave it to him.
Yeah,
I won't do that again.
That's the price he wanted for today.
that's right.
Okay, we're going to start off with the first case. This is on in your materials on page 1. This is Dudley's case, and he's going to tell us a little bit about admissible evidence by way of a CHP dash cam video.
Yeah, so just generally, this is an applicant who was a truck driver and who was pulled over and resisted arrest. So those are your kind of basic facts. And there was really 2 issues in this case. One was the admissibility of the dash cam video. As you know, CHP officers have cameras on their vests, and those film the interactions that they generally have with the public. In this particular trial, the defense attorney wanted to offer that dash cam video, and the applicant's attorney said, well, wait a second, we need more of a foundation, we need a chain of custody, and the workers' comp judge said, yeah, you're right, you know, we need more of a foundation before we're going to let these videos in, and so he excluded it, and in the course of excluding it, made comments to the defense attorney that really belittled the defense attorney, that were really disrespectful, and so the case goes up, the defense counsel recons it, and the commissioners basically said, well, wait, time out, the appeals board under Labor Code section 5708 is not bound by common law or statutory rules of evidence. And it says that there's really no rule to, or no requirement to authenticate writings, including QME reports, and sort of generally describes the looser rules that apply to workers' compensation cases. And so on that basis, they ruled that the dash cam video should be received. And then they also addressed the disqualification of the judge. And as many know, I was a workers' comp judge for 12 years. And I think, and I've been in this business for 33, I can't think of any cases where a judge has been disqualified. It's just extremely rare. In this particular case, the commissioners did disqualify the judge. And they cite the Code of Judicial Ethics, which all workers' compensation judges are bound by. And they basically said that the comments made by the judge were belittling to the to the attorney's ability to litigate the case. And as I was reading this case, I was kind of looking at the future proceedings that were going to occur and how this defense attorney would feel if he had to deal with this same judge after basically being told that, or after his competency was questioned. The judges, I think we can probably guess what firm this defense attorney came from, but the judge's comments were, I suggest you look to your boss's treatise. You clearly don't understand your boss's treatise. Wow, I think you need to read your boss's treatise. You might want to review it, and it would be helpful for you to review. So he's really saying that, you're not really competent to be in my courtroom. I think that's the inference from that. And as a judge, I think the most important thing a judge can do is really not make either side, anybody appearing in front of he or she, to feel less than. And clearly this judge would, in my opinion, this judge went too far. So the judge was disqualified. But again, I don't know about you guys, but it just happens so rarely. I once had a trial with a police officer, and the judge, with my client in the courtroom, said, Mr. Phoenix, we all know the police officers are liars. And I'm like, the trial was just starting. I'm like, what did I just hear that? And so I filed a petition for disqualification, and because my client was in the courtroom, and I really felt like I needed to defend his honor, and that was denied. They said the judge will do better next time. So that is pretty much the Johnson versus Lexmark case.
Yeah, two comments here. First of all, this case didn't originate with my office. So. And then second...
Well, judges don't know about your treatise, that's the problem.
Yeah, maybe, huh? And then second, I have a topic of discussion that falls in here that I want to, and I've discussed it with all the panelists, and I want their intake. Here's the hypothetical. Admitted injury, take a deposition, identify all evaluating, treating, and prescribing physicians. Following the deposition, you subpoena medical records from each healthcare provider identified. Counsel for applicant, upon receipt of that subpoena for medical records, files a petition to quash. The WCJ issues a tentative ruling to grant that petition, to disallow my subpoenaing medical records. This is an actual file. I call up counsel for applicant, and I say, and this is a reputable, this applicant attorney I respect and I like. It's not like we're having a war. Anyway, I call him up and I say, hey, what the flip? And he says, well, Rich, my client has a right to privacy. And I said, yeah, but the litigant exception swallows that up. And he says, no, you need to revisit Britt versus Superior Court. And I said, no, you need to revisit Williams. It's a 2017 decision. We went before the judge. The judge intimated she was inclined to uphold what the applicant attorney position is. In further discussions with counsel for applicant, he says, well, how about this, Rich? I'll get all the medical records. I'll see if there's anything worth fighting over. And you know how I'm a pragmatist. I will fight like a dog if you're you know what. But otherwise, I just as soon get to the end game, which is wrap up the damn case. Okay? And defense attorneys, I don't have a monkey on my back for billables. Defense attorneys that do may handle that situation differently than I do, but I'm a pragmatist. Get to the end game, settle the damn case. So I said to him, well, fine, and I memorialized that agreement in writing. He subpoenas the medical records. He gets a little over 900 pages of medical records. He goes through them. He writes me a letter and says he's going to send 93 pages. 93 pages. I write back, and we had some conversations, and I said, listen, if you think the law is what you think it is, I would just make two arguments. Number one, why isn't anybody else doing this? And number two, your version of what reality is that the applicant attorney gets to review their client's records without any oversight, without any input from the defense attorney, and decide what goes to the, and by the way, there's one other fact. We have 2 AMEs in this. So it's not like we're going off to a wild card QME that we don't know. We have 2 really reputable AMEs. I won't tell you who the doctors are, but I agreed to them because they're solid doctors. So here's my question to the panelists. In what universe is Richard wrong? And I want to add one more fact. His solution is that we agree to George Mason, and if you don't know retired Judge Mason, solid guy. If you want an arbitrator or a mediator, and I'm not getting a piece of the pie here, George Mason is a solid guy to act in that. And I'm not opposed to George Mason going through everything, but that's going to cost us $3,000, $5,000, $7,000. So he says either he gets to pick the records, or my client has to pay $3,000, $5,000, $7,000 to an agreed upon mediator to go through the records and decide what goes and what doesn't. And then I'll tell you what the law is, but I want to hear from everybody.
Can I ask 2 clarifying questions? One, what was the argument of the petition or the motion to quash?
It was not about what was in the records. It was just about the right to privacy.
And secondly, was it all medical records or specific providers? In other words, was this a back injury and you were subpoenaing the client's OBGYN records, or was this, a back injury and you're subpoenaing chiropractic records?
It's primarily a back injury, but I want to address that argument twofold. I wasn't after OBGYN and I wasn't after mental health, as far as I knew, but I don't know, do I? I don't know. Until I get the records, I don't know. So it wasn't that type of an argument. That might be a closer argument, okay? What I think is the records being excluded had to do with relevancy. The applicant attorney said these aren't relevant. Well, how do we know? And I want you to think about my position. How do I know what's relevant? Last time I looked, I'm a JD, not an MD. So let's get the records to the doctor. Let the doctor decide what's relevant and what's not. And isn't that a denial? You can tell I'm a little impassioned on this. Isn't that a denial of the defendant's due process rights?
Oh, you don't have due process. Stop it.
See?
So this is
See what
usually
this is why I invite these guys.
So this issue usually comes up at the applicant's deposition for me, right? Where the defense counsel says, "Well, who's your primary treating physician?" Or, who is your general practice physician? And I raised the, Allison objection, like, wait, my client has a right to medical privacy, and the only body parts that are relevant are the body parts that are put at issue in the application. And so that's how I limit it, because I quite frankly don't want to review the records personally. I'm just too lazy. So I try to catch it at the deposition. But here it sounds like defendant got the names of the providers and went ahead and subpoenaed them. Yeah, go ahead.
Yeah, just 2 facts there. Number 1, the objection was not made at the deposition. And number 2, let's address the Allison objection. Allison is, as I read it, is a case of reasonableness. What they wanted to do was first of all, a critical fact in that case is the orthopedic QME said, I want these records. He actually delineated what the scope of relevant records should be, okay? They went after, and you could tell there was a fight between the applicant attorney and the defense attorney. And I don't care if you're an applicant or a defense, if you want to fight, you're not doing anybody any favors. If it gets personal, and I think in that case, reading the case, it looked like there was some animosity there. But so the defendant goes out and he wants everything, and the applicant attorney says, no, this is what the QME says. So those facts are a lot stronger. And what they said there was that you're entitled to go back a reasonable period of time, but not the full time. And what I do at my depositions, I limit. Please identify each and every healthcare provider who has treated you or examined you going back 10 years from the date of injury. I think I probably get all the records during that 10 years. I think that's reasonable. Then I say, please identify for me each and every healthcare provider who has treated you, say the back's injured, for your back, for your spine, throughout the course of your life. Please identify each and every injury. I think that scope might be
I would respectfully disagree.
Okay.
Because I think it's not the time frame that's relevant, whether it's 10 years or 20 years. I think it's the body parts that are relevant. And I think the body parts that the applicant waives his right to, or her right to medical privacy on, are those that he or she puts on the application. So if it's a back claim, I don't think you get to learn about sexually transmitted disease or something very of a personal nature. I just don't think that that's anybody's business, and it is subject to the right to medical privacy. So I think it's more of a body part issue, and it gets closer. Like if it's a back claim and the applicant's treated for a neck or a knee, I'm a little looser on that because that could have overlap consequences. It could be relevant to the back claim. But if it's a prior cancer diagnosis, something clearly that's unrelated to a back claim, I would push back on that. So I disagree with this, the nature of the right to medical privacy, but my point is that I don't think it's up to applicants' counsel to review the records once they're subpoenaed. I don't think that that's the right mechanism. I do think you need a third party, and I think that's what the Workers' Compensation Appeals Board is there for. So I would just ask a judge for an in-camera review of all these records, and for the judge to sort through them and determine how much of it is in fact subject to the medical privacy. So that would be my proposal.
Yeah.
Because the judge gets paid by the hour to do that, right?
No, I mean,
I don't make any friends with judges with that. But I'm just,
Right.
and by the way, I tend to agree with you more on the records. I think it is an issue of scope of discovery and how much you're entitled to get based on what the allegations are. So I've always gone out of my way to try and respect the applicant's right to privacy on issues which really don't have to do with the industrial injury. I don't need to know about their OBGYN records. I don't need to see their prior drug and alcohol history if it's not relevant to our existing case. But you're right, it can be difficult to make the distinction of how do you know that you have it or not. Right.
Okay, here's one caveat here, and this is why I say 10 years, and it is scope, and it's arguably limited by the part of body, but it's not only the treatment and the diagnosis, it's the factual history that may be in those records that may be relevant for the doctor to review, and the overlap. What if one treatment that you think is completely, we as attorneys think completely is unrelated, and the doctor, our orthopedist says, aha, look at this, and look at this, and look at this. Now I see the connection, now I see the dots. And so that's why I think it's relevant. I'm going to tell you, we have to balance competing interests here. And let me give you the cases that, because what happened was, when this happened, this will tell you about how exciting my life is. I was up till 1:30 going down the rabbit hole, reading everything out there that I could possibly find. And I came across a few cases, and I cited them back, and it kind of put counsel for applicant on his heels. Of course, he's citing, and you may want to write these cases down. He's citing Britt versus Superior Court. That's 20 Cal Supreme Court 3rd, 844. We've already mentioned the Ellison decision, Ellison versus WCAB, and that can be found at 72 Cal App 4th, 654. But I would argue, and understand, we're talking about the right to privacy, and then more specifically, we're talking about the right to privacy as it applies to medical records. And this is the Williams versus Superior Court, 3 Cal 5th, 531. And what this case says is absolutely they have a right to privacy. The issue is, what's the standard? What are we going to apply to allow that right to privacy to be overcome so the medical records come out? And they talk about the litigant exception. They talk about strict scrutiny and when it applies. They talk about the Hill case. And let me give you the Hill case. Hill versus NCAA, 7 Cal 4th 1. Now, these are all right to privacies not dealing with medical records, but I think they apply here. And what the standard is. As a general rule, I'm just going to tell you, in 35 years, I've not seen anybody make this argument on medical records. I've seen the argument like Jason's making, where, listen, these are psych records, we're not throwing psych in there. The exception to that is where it looks like there's subjective complaints that are out of line with objective findings. We have to figure out why that is, right? And then there, if they have even if they're not making a psych, and the way I use that is I argue, listen, I'm entitled to psychiatric records. I'm going to use these psychiatric records to establish there's a valid basis for apportionment, and or the subjective complaints related to the orthopedic injury are not part and parcel. They're separate, and that's what we're looking at, a non-industrial psychiatric claim. And I use that to settle a case. And counsel for applicants often do that. But I think I'm entitled, and I press this, I think I'm entitled to all records for a reasonable period of time and all records dealing with the part of body. And then, if that's the general rule, then if you have something, you have a valid argument. And I do have relationships with applicant attorneys, and I will say, if they subpoena those records and they say, listen, Rich, and we'll have candid conversations, I may let them get away with it. Because do I want to start a war? Do I want to start a fight? But I will tell you, I can't tolerate a case where we've subpoenaed 900 pages. I don't have them. I've never looked at them. I've not been allowed to. And he wants to send 93. You use the adjective, right?
So can I just say something? I agree with you. Well, I think that
You're sympathetic to.
I'm sympathetic to your concern there, but I think that if you take the position that, like, well, look, we have the records and I can't see them, so how do I know that they're not relevant? I think that logic will basically vitiate or defeat the right to medical privacy, because
And it does. The cases involving litigant exception pretty much say that, because they apply the Hill standard. Let me read this to you. The Hill factors are: one, whether the legally protected privacy interest exists. It does, right to privacy. Whether there is a reasonable expectation of privacy under the circumstances. There is. But here's whether the infringement on the privacy interest would constitute a serious invasion of privacy. And I would argue, as soon as you file that work comp claim or the PI, these are PI cases, guess what? You've just waived that right to privacy to the extent that it is relevant and understand under Greyhound, it's relevant or reasonably calculated to lead to the discovery of admissible evidence. Generally, discovery is supposed to be broad. We're supposed to find out. And I understand from the applicant's side, the applicant attorneys are saying, well, hold it, Rich. My client, so what you're saying is they file a comp claim, they have no right to privacy? No. I'm saying it's a balancing test that generally is skewed in favor of the discovery.
Great. So I would say this maybe is a bit of a pet peeve for me, and it's an issue I've spent a lot of time on. And when I left the bench, in all of my depots that I was doing, the defense counsel were like going, gosh, the other applicants aren't making these sorts of objections, and I was certifying questions. And so it's sort of a pet peeve issue for me, perhaps. But I do feel strongly that if the applicant hasn't put the body part at issue in the application, that the defendant does not get those records or does not conduct discovery on unrelated body parts. I think that's the analysis, and I think, but I do think that it's up to the appeals board. Once the records are obtained, it's up to the appeals board to then rule on the medical privacy issues. There for sure is a right to medical privacy. The question is, how far does that right extend?
But what do you do with my argument that I'm not a doctor, I don't know what's in there, and there may be factual history that's inconsistent and relevant?
Well, look, I'm dealing with this not on your facts, but the other way, where I've got 3,000 pages of subpoenaed records from Kaiser and UC Davis that have to go to the QME, and defense counsel saying I'm going to send pages 1 through 15 and 23 through 28 and et cetera, trying to pull out all these, extraneous pages so they're not paying $3 a page. And my argument, and I've made this successfully in court, is, hold on, I'm not a doctor. How in the world do I know what's relevant? Like, I get that this is going to cost you a lot of money because of the way the fee schedule works, but if we have these records, it's not up to you, it's not up to me to decide what's relevant, it's up to the doctor to decide what's relevant.
And you know what? I'm consistent. When my clients raise that issue, I just look at them and say, you got to pay to play. I'm not a doctor. You want me to go through, I summarize the records, you got a bill there, I can go ahead and do this, but I'm not a doctor. That's why some of my clients will not let me use AMEs. You want to go to a panel QME and play Russian roulette? Often that's what happens. And I want to make a point here on the medical legal procedures, because this is a defense attorney's pet peeve. It is like playing Russian roulette. You may get a great doctor, you may get a crappy doctor, you may get a panel with 3 crappy doctors from the defense perspective, and we are stuck. And I have clients that will not go off to AMEs, and I just shake my head thinking to myself, what the flip is going on here? And even after, now they may subsequently agree where it's a pain management panel and there's 3 doctors and now they have us. But no, but I tell my clients the same thing. Listen, if you want to fight this, I don't know what records to send. And what if I pick the wrong records? What if there's something in one of those records that actually supports my defense, and I don't know? What do you do with that? And I've just excluded it. Do I want that kind of a responsibility? And then later, 2 years later, some doctor says, you know, I heard this history, and I wish I would have known. Well, what do you do? I really think that the answer to this is pretty simple. Select good doctors off of PQME panels. You can see with my nonverbal cues, or good solid AMEs that are going to review the medical file and that you trust. Is that too simple?
And by the way, I'd point out that currently, I would say 2 out of 3 QME panels, I see doctors I have never, ever
Oh my
seen
gosh.
before.
And I get calls, I don't know if this happens to you, Jake,
Oh, yeah.
but I get calls all the time for Northern California panels from Southern California firms, and they go, hey, Rich, do you know this doctor? You know this doctor? You know this doctor? And I have to say, wow, you impress me, you flatter me with the question, but no, I don't know this doctor. So that's what we're dealing with.
Yeah.
It's
A lot
tough.
of new doctors in the field that we just haven't seen and have no experience with.
But if the defense counsel out there are faced with this issue, because I know this firm is making this argument consistently. Look at the Williams versus Superior Court, 3 Cal 5th, 531, and then it cites and discusses, and you should also review the Hill decision, which is Hill versus NCAA, 7 Cal 4th, 1. Be aware that they're going to argue that those are right to privacy cases, not involving medical records. Okay. Hey, you know, one thing I haven't said is the panelists up here, we don't have all the answers to the solutions. And as I look out there, there are some attorneys on both sides that probably would have some valid input. So if you have something that you want to comment or a question or something like that, we'd rather you ask it than throw something at us. So, okay, the next case is, I think this is a case of really direct causation. Whenever I see an apportionment case, and this is going to go to Jake, whenever I see an apportionment case, I look at I try to explain them with 3 doctrines. I always look at these 3 doctrines. I look at, because I have to figure out what's going on and put it in my book in the right spot, and who knows if I'm right all the time. But I look at substantial evidence. A lot of a failure on the defense part to establish valid legal apportionment is their failure to meet the substantial evidence test. The second is burden of proof. If the defendant doesn't meet the substantial evidence test, they failed the burden of proof, and the applicant attorney doesn't have to do anything more because it is the defendant who has the burden of proof. Last, direct causation. I think, and this is what I've always said, cases like Halkitis, it's really a direct causation. What caused that disability? Is it directly flowing from an industrial event, activity, or exposure, medical care? And if it is, there would be no apportionment, even though the underlying injury or diagnosis would be apportionable. So what do we need under 4663 for substantial evidence? This is my checklist, and I say this over and over again. Number 1, whenever I read a report, I want to know that there's a full, complete, and accurate medical history with a proper diagnosis. A full, complete, accurate medical history with a proper diagnosis. Number 2, the opinion has to be expressed in terms of reasonable medical probability based on the doctor's education, training, experience, and understanding the facts involved in the case are presented to them by way of a hypothetical. And last, and here's the critical part, the how and why, the considered and reasoned analysis. The doctor has to connect the dots. He has to take, broadly speaking, 2 areas of evidence. Factual evidence, how it injured, subjective complaints, what's going on there, and medical history, medical evidence, diagnosis, diagnostic studies, that sort of thing. And based on those 2, he has to say, yes, there's apportionment to non-industrial, prior industrial causation, or subsequent non-industrial or industrial causation, unrelated to the specific injury that has resulted in this level of disability. Okay, with that as a backdrop, we're going to turn this over to Jake for the Cruz case.
Okay, and I think we're done. We can go on to attorney's fees now.
I'm sorry.
No, and after considering the discussion on discovery, the fact that this is about headaches is certainly appropriate. In this case, the applicant had cumulative trauma injury involving multiple body parts, significant ongoing problems. One of the problems was she had rather severe headaches. Now, under the AMA guides, the maximum rating for headaches is 3%. Not a whole lot there. A lot of doctors sidestep that using an Alvarez-Guzman analysis by using the rating for trigeminal nerve under the neurologic section. And that caps out at 14%. And in this case, the neurologist gave the applicant a 14% impairment, saying that's the maximum impairment I can give for a headache. But in reality, the applicant, as a result of the headaches, has to miss time from work, sometimes 2 or 3 days a week, has to have an extremely flexible schedule where she can go and lay down in the dark room or else go home, that her headaches are really, really severe. I think it would be really, really difficult for her to even work or be considered for full-time employment with these headaches because of the extreme variability, the extreme severity, and the fact that they just simply don't allow her to function. He also gave apportionment based on the fact that she had had headaches during her menstrual cycle over the years and had periodic headaches of perhaps 2 or 3 headaches a year that lasted for maybe a day. He said, based on their history, I would give a 1% impairment, or 1% apportionment to pre-existing headaches, with the other 99% being related directly to her work-related injury. Her orthopedic complaints and other complaints in this case rated out to 64%. The judge took the approach that the headaches essentially rated 99% on their own, but even when you combine those with the occupational injuries for the other areas, the 64%, you still ended up at 99% under the combined values chart. Now, apparently nobody asked any of the doctors about adding versus combining. That doesn't appear. It also doesn't appear that the applicant attorney obtained a vocational expert, which I would be surprised at, because this is kind of one of those cases that looks ideal for obtaining a vocational expert to quantify the ability to work with that severe of a headache in the light of a rating schedule that could only give it a 14% rating. What the trial judge did, however, was simply basically say, I'm going to rate this at 100%. I think it's doesn't make any sense to combine a 99% functional disability with a 64% rateable disability and come out still to 99%. I'm bumping the applicant to 100. The appeals board said it would be an absurdity to combine a 99% disability with a 64% and still end up at 99%. And basically, this is one of those cases where they ran roughshod over Fitzpatrick and all the case law in order to simply say, this person's permanent total. The discussion on apportionment was pretty brief, but basically they said the doctor really didn't give enough of an adequate explanation. My opinion, I would really like it if the board would apply the same criteria for apportionment and then also apply it to analysis under Kite instead of accepting any other just sloppy opinion on Kite as being gospel. But in any event, in this case, it said the judge did, or the doctor didn't give a good enough explanation as to why there should be apportionment for what appears to be basically an unrelated condition. The fact that she had headaches compared to the headaches that she now has seems like apples and oranges. And that's kind of the way I took the approach on this.
Yeah, when you have that high level of PD, you really have to be a pragmatist. But tell me this, Jake, and I was surprised that there was no VR evidence in this opinion. Is this a case where perhaps a defendant might want to get a VR expert to establish some meaningful level of earnings or job-related?
If with better facts, perhaps. I'm not sure, given the description by the Green Medical. This is a case where, frankly, I mean, I'm sure it happened. You'd really want to put in some serious efforts in sub rosa to see if you can show that the applicant's actually functioning in a manner that's not consistent with what the doctor's describing. Yeah, that's where it's going to, and that might be your only shot at getting something like this. Now, this is a panel QME, so we have no idea. This is sort of the Russian roulette that you get with panel QMEs. You have a panel QME who's giving extremely high factors of impairment. Now, there's lots of different kinds of treatment for headaches. So that would be one of the other issues that I would certainly want my client to explore is, are there treatments that can mitigate this, other than just giving her Imitrex, which is what the doctor said the applicant took?
Yeah.
So to see if you can have some impact from that standpoint.
Yeah, what triggered me on this case was the orthopedic rating. Whenever, I'm always, I'm a defense attorney. I'm always a little bit suspicious of headaches because we can't validate them. There's no way to verify them. But we also had 64% whole person or disability related orthopedically. So that tells me, bam, we're close to a life pension on this. And whenever I get in that area, I'm always recommending, just to validate what's going on, surveillance. And I've written letter after letter. It's 3 to 5 days over as many weeks. That's what I say, because you may or may not catch them. And the reason we do that is to make sure that what we pay for is legit, that we have some. The other thing, and this is why I raised the vocational expert, I've had some success in settling cases by making an argument that there are alternative employment opportunities out there due to technology that will that provide meaningful, gainful employment, that they can actually have legitimate earnings. I mean, what we're doing with computers and working in home, we're going to talk about in-home injuries later on today, but those are all part of a way to potentially, and I'm not going to say they're winning, and I think Jake is right about that, but they certainly provide the defendant with something to argue when it comes to settlement negotiations. So, okay, the next one is attorney's fees, and Jason's going to...
Yep. Can I just want to talk just for 1 second. One of the cases that you have in here, the Santiago case in your little box, is a really interesting case. Santiago is a case where the applicant had a prior stipulation with request for award of 43%, 18 of which was identified as being related to his cardiac condition. He then files a subsequent claim during the same employment, files a claim several years later, cumulative trauma involving heart trouble, where he gets a 55% rating. And the issue is, does the employer get apportionment? And at least according to the analysis here, and based on some prior authority also, the employer does not get apportionment because of the anti-attribution clause. You're not allowed to apportion to pre-existing factors when you meet the criteria for a presumption under the cardiac provisions. So I found that to be an interesting case, and I hadn't seen the prior case, so this was sort of a new case for me. To me, it did raise one issue. I'm certainly thinking, what do you do with the cap at 100% on cardiac cases? Suppose the rating was 55% for the first rating, and then the second rating is 65%. Do you still cap it? Because according to the analysis, even though 4663 says you get to, or 4664 says you get to subtract impairment, the question is, does a provision about having the 100% cap on any individual, one of those 7 different body parts, does that also apply? The case doesn't really address the issue, but I think it obviously, at some point, we'll have that come up.
How do you come down on that?
I think it has to apply.
Yeah, I think so too.
I think you cap out at 100% for, and because it involves actually the whole internal.
Yep.
I mean, the 7 body parts are kind of disparate.
And we're going to be talking about a case a little later on about whether or not, you need to understand, where you have separate dates of injury, separate parts of body, and we have this case in here, you need to understand the rule is not that you cannot have ever somebody who's deserves an award above 100%. But with regard to a single date of injury and different parts of body, that can be 100%, and then you can have a separate and distinct injury, separate part of body, no overlap, that's critical, where you can receive a separate award. And we're going to be discussing that case a little later on.
You can actually get about 670% because you can only get about 70 for hearing loss, which is separate.
See, I haven't worked the numbers on that. Okay, now we're up to Jason Marcus's favorite topic.
Yeah. So we have 2 cases here on attorney's fees. I'm going to try to go through these quickly. The first is Swain. This is a case where the applicant attorney was claiming attorney's fees for a deposition that was scheduled but did not go forward because the applicant, the injured worker, failed to show for the deposition, apparently because they forgot about it. I think this was depo number 3. There had been 2 prior depositions for which the attorney had been paid 5710 fees. And ultimately they CNR'd the case but reserved the attorney fee issue under 5710. And ultimately the attorney lost. And basically what the board said is, look, 1, 5710 fees are discretionary. Yes, it provides for it in the labor code, but ultimately it's up to the discretion of the judge. 2, they made a distinction between a deposition actually proceeding and this situation where it did not, because again, the injured worker failed to show for the deposition. And then there's some other commentary about how much the attorney was requesting an hourly rate versus apparently they sent a hearing representative to the deposition. I think it's a Southern California case, and if anyone here is from SoCon, I'm going to offend you. Sorry. But personally, this is not the kind of thing I would fight with or deal with or file an appeal over. If any of you practice at the Sacramento board, I've been on a number of conference calls over the last 3 years and hearing judges admonish people over fights about 5710 fees or finding creative ways to incorporate them into a settlement. It's not going to fly in Sacramento. I don't know, Dudley, if you saw that as a judge, people where they try to CNR the case where they settled at the deposition and then, we're going to add extra for attorney's fees or something. I don't do that. I don't think it's going to fly with anyone in Sacramento. And I think the moral of the story here is be a little more judicious in what you ask for. I appreciate that, depots that don't go forward can be frustrating if you've invested time, but at least according to this decision, don't expect to get paid for it.
Yeah, just quickly, so that is something that comes up where you'll see a $10,000 CNR, and then in the CNR it'll say that the parties agree to a 4-hour 5710 fee. And then the judge will say, well, why a 4-hour 5710 fee if the case settled at the deposition? And the applicant's attorney will say, well, that's how long we took negotiating the case. That's not going to fly. And the Sacramento judges are aware of that approach, and it's not appropriate.
Right.
This is a question for Jake. I'll bet you I know the answer to this. In your entire career, how many 5710 fees have you adjudicated to hearing?
1.
Okay. And I never have. And let me tell you why. Because the amount of money that you're going to pay me is 3 to 5, maybe 7 times, if I do my job right, the amount that you're going to save on the 5710. And so I never recommend, now don't get me wrong, I'll negotiate it. If somebody's charging too much, if they want travel, if it's a Southern California firm, I'll argue with them, and this is my argument. It's pretty simple. I have a long memory and an equally as long career, I used to say this, ahead of me. I'll remember this. So let's get to the end game. Let's wrap this issue up. And that's the way you handle it. If you have defense attorneys who are saying, we need to litigate, all they're doing is trying to engender litigation and get the claims examiner behind them, and I just shake my head. I just don't fight over 5710 fees, and I never have.
Yeah, the most I think I'll do is if I haven't been paid, I'll file a petition, and usually it gets approved by the judge. I have bigger things to do than fight about that kind of stuff, at least personally. Next case is, I don't know if it's Pena or Pena, but this is, to me, a really interesting case. I also think it's very, very fact-specific, although I'm glad we included it because if you go read the actual decision, there's a lot of discussion about how to handle credit. So here's the situation. This was a case where the injured worker was totally disabled. I don't know if the parties stipulated that. I think they went to trial and got an award of 100%. Either way, there was no question the worker was totally disabled. The worker's attorney, who's a friend of mine, Bill Herreras, down in the San Luis Obispo area, requested a fee and was awarded a 15% fee, but the judge, 1, did not order the fee to be commuted, and 2, ordered that Mr. Herreras' fee, along with the injured worker's permanent total disability award, were both subject to a third-party credit of about $474,000 and change due to a third-party recovery that the injured worker had recovered arising from the third-party action from the same accident. The problem here was that the third-party credit, which the injured worker and the injured worker's civil attorney and the civil defense attorney had agreed to, One, had never been approved by the Workers' Compensation Appeals Board prior to submission for trial, and two, was not approved by, made aware of, or agreed to by Mr. Herreras, the injured workers' compensation attorney. And ultimately what the board found is that in those situations, the third-party credit was invalid for a whole number of reasons. One, there was no indication that the injured workers' workers' comp attorney, Mr. Herreras, had ever been made aware of it. In fact, I think as part of the trial decision or the recon that went up, Mr. Herreras submitted an attestation saying, I wasn't informed, I wasn't advised, I didn't sign off on it. Two, I think the biggest issue is the third-party credit, the stipulation of credit, had never been submitted to or approved by the WCAB. And anything that deals with resolving an issue in a workers' compensation claim, be it a credit, be it the claim itself, be it any other issue, is invalid unless it's approved by the WCAB. Our courts have exclusive jurisdiction over any issues relating to a workers' compensation claim. So, if someone as part of a civil settlement says they're going to waive or settle their workers' comp claim, unless it's approved by a workers' compensation judge, it's not valid. And then three, the court looked to balancing of the equities. I think they cited the Maples case. Anytime you're dealing with credits, ultimately it's a matter of equity, and the board has jurisdiction to address that. And here they found it was inequitable to apply the credit both to all of the benefits that we're owing, to apply it to the attorney's fee for the work that Mr. Herreras done. The other thing that the injured worker had done apparently as part of their agreement with the third-party defendants is not only agreed to the credit, but said it was applicable against all benefits owing now and in the future, including medical treatment. So not just their permanent disability award, but medical treatment. And the board said, we're not convinced that that's appropriate or correct. They ultimately remanded that issue down to the trial level to address. But what the board found is they would allow the credit against the injured worker's future permanent total disability award, but they also allowed Mr. Herreras a 15% fee off the present value of the total disability award, with that fee to be commuted from the worker's award. So I think the moral of the story is if you have a third-party case and you want to get a credit and actually have that credit apply in the workers' comp case, one, if the worker has a workers' comp attorney, by all means, you better include them in those discussions. And two, if you have a stipulation, you better get it approved by the Workers' Compensation Appeals Board.
And of course, that's Bill Herreras. He's a past president of CAW that was on this case. He's also addressed been a presenter at this conference. I just received a question, and I'm going to throw this out to the panel. They don't. It says, can the panel address when, if ever, more than 15% fee, attorney's fee, is justified?
So one of the things that CAW had a panel on this last convention was attorney's fees.
I'm shocked.
I wasn't on that panel. I have my own personal view about attorney's fees and how one should handle them. So let me be clear. I'm not speaking on behalf of CAW. I'm speaking on behalf of Jason Marcus, workers' compensation attorney. I think we're entitled to be paid for the work that we do. For me personally, I can think of one case in the last 10 years where I asked for more than a 15% fee, and it was because it was a complicated story, but ultimately it was a perm total case where I agreed to take my fee as a level commutation like you would get paid in an SIBTF case rather than a lump sum commutation due to a variety of reasons. And so to kind of account for the risk that I was taking on that, I got my client to agree to a higher than 15% fee to be taken out of his checks every 2 weeks, so I get paid a little bit more than 15% on an ongoing basis. But beyond that, I can't think of a time where I've asked for beyond 15%. I am aware that in some places across the state, maybe in Sacramento, certainly others, people are requesting and getting approved fees higher than 15%. I've seen 18%. I've heard of 20%. I haven't felt the need to do that. I don't know. I'm not really sure if I have a strong feeling on it, other than I wouldn't do it personally. But
I have seen attorneys get fees of up to 25% for a series of willful misconduct cases, because those are much more like trying a civil case than they are like trying a workers' comp case. But again, we're at the appeals board, so it's not quite the same level of time and effort, but it takes more than your typical workers' comp case. So I've seen judges award up to 25%. I see a lot of applicant attorneys that when they agree to take either an S&W or 132A, that they ask their client to agree to a 25% and then get that ratified by a judge. I can say when I was an applicant attorney, I can only remember one time asking for a higher than 15% fee, and it was a death case that went up to the Supreme Court. The defendants did not get one vote from the board, the Court of Appeals, or the Supreme Court on the case, but I got the judge to award a 15% fee, and then an 18% fee, and then an 18% fee on the interest, which was almost as much as the award. It was a $55,000 death benefit in those days. So the interest alone was almost more than the award was.
Wow. So, yeah, personally, I've never requested more than a 15% fee. I don't think I can think of a single case. As Jake just mentioned, I've had Judge Samuel in Sacramento award me a 25% fee after a 2-day S&W trial, although I wasn't requesting it. And I don't know. My philosophy has always been try to be conservative with that. Financially, I've always done quite well. And so, I just had a case last week where I asked for a 13% fee, $265,000 CNR, because I hadn't had the case for that long, and that's what I thought was reasonable. So I don't think I've ever asked for 15. I think I was one of the last attorneys to even go to 15. I was asking for 12 for quite a long time. But so I don't think I can think of a case.
I'm just a pragmatist on this. It doesn't involve my client. We're not paying any more money. That's between the applicant and the attorney. Having said that, why is it, I want you to think about this, and I've said this forever, why is it that somebody walks across the street and gets hit by a truck on their way to grandmother's house? Their attorney gets 30 to 40%. Somebody walks across the street making a delivery and gets whacked, and their attorney gets 15%.
Of just the disability.
Yeah, of just the disability.
Just the permanent
Point taken.
disability.
It's risk. I don't think I have nearly as much risk in a case like that as my PI counterparts do.
And I hear that all the time. You know what my counter is? I don't know why I'm arguing for applicant attorneys.
Keep going. This is good. You tell us why we should ask for our fees. So when I go to the judge, Your Honor, Mr. Montalvo said I should. I don't know what to do.
You're going to be called as an expert witness here, Rich.
Yeah, that's fine. No, here's the problem. Do you think the PI cases, there's risk there? They only take the good cases. Personal injury attorneys take the good cases. They have somebody take intake that says, oh yeah, this is good, and then at any time they can get rid of the case. So realize, or give it to another attorney. Maybe the lesser PI attorneys don't, but the risk with the top PI firms is not any greater. And I thought what you were going to say is it's a standard of proof, because we have to show negligence in PI, whereas here it's presumed compensable. So that I understand that distinction, but I just think that for what they do, and given the complexity of workers' compensation and what we have to know and the rating, and I mean, there's no PI attorney many of them don't do workers' comp because of the complexity, and they farm it off to work comp attorneys. So that's just my 2 cents.
Well, in fairness, a lot of the clients that I talk to, when I have my initial consult and tell them how we get paid, they're like, that's it? I'm like, yeah, we get paid 15%. They're like, well, what if we lose? I'm like, well, I don't get anything. Well, what do you mean? I mean, they're by and large, I think they're shocked that that's it. Or especially if they've dealt with PI FERC, they're like, whew, okay. They're like, it's only 15%. So,
But as an applicant attorney, I'll spend incredible amounts of time on a case that might be 5 or 10%. And then yesterday I walked through STIPs for 100%, where the fee's $200,000, and it was pretty straightforward. It was a couple of years, but so there's just such a variation between. And I really try not to really think about attorneys' fees. I usually evaluate it when the case is resolved, but I try to put the same effort in no matter what the file is. But I can tell you some of the smaller cases are a lot harder. just seems to be the way it works.
Yeah. Okay, the next case is mine. This is an interesting case, Demokmos. This case involves a murder. So this is the murder case. We've got the decedent, the husband, and the wife all work at the same facility. They know each other, and the husband believes that the decedent is having an affair with his wife. He goes to the supervisor and says, hey, this is what's going on. I would have suggested he just goes to his wife. They go ahead and they move her shift so that she doesn't have to work with this guy. Sometime later, the husband shows up at the workplace and kills the decedent. The issue is whether or not the decedent's dependents are, whether or not there's a valid industrial claim of injury. And the issue is, and this is what the court struggled with here, are motivations in and of themselves, are they sufficient to take it out of the course and scope of employment? And I wrote down two issues here. Is motive determinative of the issue of whether or not it's within the course of employment and whether or not it arises out of the course of employment? Well, clearly it was within the course of employment. The guy was working, he was providing services, benefit to the employer, he was an employee. That's where it occurred. Did it arise out of employment? And what the court did was they looked at whether or not there were sufficient contacts with the employer to bring that within the course and scope of employment. And they looked at the following factors. The three worked together. This wasn't a husband outside that didn't work. The three worked together. All three met at work. The murder occurred at work. The supervisor became involved in the situation. The supervisor changed the work schedule. What they said was there was a sufficient connection between the murder, irrespective of the motives, to bring that within the course and scope. And they cited and discussed the Schick case, the, what is it? Slick case.
Schick. It's Schick.
Schick? Okay,
Yeah.
Case. This was an interesting case because it involved an employer who hired the employee who was killed to go out to private residence and measure table pads or cloths or whatever. And her husband, ex-husband, they'd been divorced for 3 years, set up an appointment. When she arrived, he killed her. And the issue was whether or not that arose out of the course and scope of employment. And what they said there was it did. The mere fact that there were personal motivations for the death as and when it occurred is not determinative. There are sufficient connections to bring that within, satisfy arise out of the course and scope of employment. I'm going to read the last paragraph. In upholding the WCJ, the WCAB noted that the death had sufficient connections to arise out of employment and was clearly within the course of employment. In reaching the conclusion, the WCAB noted that despite the motivation being purely personal animus, the death was within the course of employment where the death was sufficiently connected to the decedent's employment AOE COE, where the assailant, the victim, the wife of the assailant all worked together, became acquainted through the work, murder occurred at work while the decedent was performing services for the employer, supervisor was informed, he modified the work schedule. They said that there was sufficient. Now, these are my thoughts on this. How do we reconcile all this? What's the general rule? Well, I write that the general rule that this decision should be viewed as an exception to the general rule that where the assault occurs for purely personal reasons and simply takes place at work, it does not arise out of the employment, but rather the workplace is merely the stage upon which the incident took place and thus does not arise out of and is not incident to the employment. So that's the general rule, but there are exceptions, and what the applicant attorney needs to do is find those connections with the workplace that justifies bringing that within an industrially compensable injury.
Yeah, the Schick case is interesting to me. The very first research project I ever did as a young lawyer while I'm waiting for the bar exam results was to do a research project involving someone who'd been assaulted at work by her boyfriend. And Schick was the main case I was looking at. So I read that case over 25 times probably. It still is in my memory. The key to the Schick case was that the husband
What is the name of that case?
Schick.
It's really close, isn't it?
Was that the husband was able to use the ex-wife's employment to lure her to a remote location in order to kill her. Mm-hmm. So if he had actually gone into work and shot her at the store, I believe she actually worked at Macy's, shot her at the store, wouldn't have been a work-related incident. But he used the work as a vehicle to get her someplace that she would ordinarily not go, except for work, in order to be able to kill her. So that's the connection that they made for this one. Because ordinarily, as Rich said, the general rule is personal assaults are not work-related. You can have neutral assaults, work-related assaults, and personal assaults. And neutral assaults are going to be found compensable. Work-related assaults, which by definition this one now becomes, are compensable, and personal assaults usually are not.
So would you agree with my general statement of the rule?
Yeah, no, I
Okay.
think so.
Okay. The next case is yours, Jay.
Yeah. and
Montani.
It's not really an AOE-COE case. It's really more of a statute of limitations case. In this case, the applicant was the caregiver for his father, who's being paid by state agency or county agencies to provide services to his father under IHSS. So he's taking his father to the doctor. On the way home from the hospital from an exam, there's a motor vehicle accident. He's injured, files a civil case, proceeds with a civil case, and then 3 years later also files a workers' compensation case. And his argument for filing the workers' compensation case late was, well, they never sent me a DWC-1, so therefore the statute of limitations never ran. Defendants contested that, and their argument was, we didn't send a DWC-1 because we had no idea this was a work-related condition. He never told us. We never saw a police report. He kept this information to himself, and in fact, the applicant actually testified that he was aware more than a year before he filed the application that it was, in fact, a work-related injury and that he could file a workers' comp claim, but he really didn't want the workers' comp carrier participating in this third-party case. So the appeals board said, statute of limitations applies here. Defendant never had an opportunity to present or provide a claim form to you. You were aware more than 1 year before the date you actually filed the application that you could file a claim, and therefore your claim is now time barred and you don't get to pursue it before the appeals board. So this is a rare statute of limitations defense.
Okay, and
for
that was
defendant.
that's what I was going to ask you. How often do you, Jake, in your practice see the statute of limitations as a defense?
It's extraordinarily rare.
Okay.
And obviously, we don't try all that many of them. A lot of them get settled for, a lot of times for fairly nominal amounts, because
Yeah.
there actually are some pretty decent statute of limitation cases. But that was this one is an interesting one. So it is important. I mean, if the injured worker doesn't give the employer notice, your obligation to provide a claim form doesn't arise. You have to have actual knowledge that either gives rise or constructively gives you enough information you should have known. They knew he had missed time from work and he was injured, but they didn't know why, because they didn't have any of the facts for it.
The next case is Kobayashi. This is Dudley's case, and you probably have experience given your practice with this doctor.
I do, yeah.
He's pretty solid, isn't he?
Yeah, I like Dr. Nori.
Yeah, and
I guess I could say his
defendants
name.
use him too.
Yeah, it's the QME in this case was Dr. Noriega, who I've used in several cases actually.
I've used them.
Yeah,
It looks like the whole panel has used him, and he's a good doctor.
Yeah,
Okay.
I've got his Amy on a case right now. So this is a really interesting injury COE case where the applicant was on a business trip, and I take it he was delivering fish, and he had fish boxed up in a cooler with dry ice in it. And he gets to the hotel, parks his car, and I think it was, 90 minutes later that he was found unresponsive. And the question was whether the dry ice, while driving the fish around, put off carbon monoxide, causing a hypoxic event. And so it was really one of causation. And Dr. Noriega said, well, gosh, there's no other causes that we can tie this injury to. And so it would have been the carbon monoxide that he was probably exposed to. But, defendant argued, I think appropriately, that, hey, what we're really talking about here is a possibility, okay? So we don't know that this exposure is what caused this response. We're really kind of speculating that this is what occurred here. And and it was quite interesting at the trial level, in the process, I guess, when you develop hypoxic, I didn't know this, hypoxic reaction is called sublimation. I like that word. Anyways, the court at trial, there was conflicting evidence as to whether the box of fish in the dry ice was actually sealed with tape, which I found really interesting because I think that would be a really important factor as far as how much of how much exposure there actually was. But the WCJ found for the applicant, and the WCAB upheld the judge, saying basically we're looking at, a mere contribution standard. And they cited to the Maher case and cited to the Guerra case. There's other cases that are really helpful in these sorts of cases where you're looking at medical causation. One is the Rosas case, where you have the sewage worker who develops hepatitis. There's also the McAllister case, which was the firefighter with lung cancer. So there's a lot of cases, and what you're really looking at in these types of cases, I think from the commissioner's level, is did the applicant prove something more than a mere possibility? And that's what the defendant in this case was arguing. Hey, we're just talking possibilities here. We're not talking about probabilities. And then the commissioners went further and said, well, okay, let's assume that we really just don't know what caused this person's injury. They cited to the neutral risk doctrine. And I happen to really like this doctrine, but it says basically where a death or injury occurs under unexplained or mysterious circumstances at the workplace, there's a presumption that the injury or death is work-related. And here, since he was apparently traveling for business, that extended the workplace quite a bit. But for all of those reasons, the commissioners here found it to be work-related.
Yeah, I have this in 2 places in my book. I have a whole section on mysterious deaths and what the burden of proof is. And this is what I would say. It has to be reasonable medical probability. It's not reasonable medical certainty. And where you have medical evidence that suggests that the causation is industrial, which we have here, then I think the board is free to find that it's industrially caused.
The Clemens case is a really interesting case in this setting, because the whole thing in Clemens is really says that where there's a death at work, which is unexplained, but the cause is something which could be reasonably foreseen as having occurred at work, there's an inference created that it's an industrial injury, and then the burden shifts to the employer to prove that it's not an industrial injury. So that's how it works. And in fact, in Clemens, with the trial judge declined to award benefits, saying that the evidence wasn't sufficient to establish injury, what the board said was, the evidence isn't sufficient to establish anything. You have to go back and come to a decision one way or the other. One doctor said it's industrial, one doctor said it's not. You can't say, I can't decide between these two. Your job is to decide. But if you cannot decide, if neither of them is substantial evidence, then the inference arises that it's an industrial death, because it could be. In that case, the applicant was found in front of an electrical panel with a screwdriver in his hand on the ground, and he had a heart attack. And the question was, did he stick it in, get an electric shock, and have a heart attack? One doctor said yes, one doctor said no. Judge threw up his hand and said, I can't tell, so I'm not going to find it compensable. Board said, no, it doesn't work that way. This is something that could have happened at work. So we're going to create an inference that it did happen, and then it's the burden. Now you have to decide, did the employer meet their burden? It did not happen as a result of that. And if they met their burden, then it's not industrial. If they can't, then the inference that it was an industrial injury applies.
And you see what Jake did there? There are 2 doctrines that help me explain a lot of cases that appear to be in conflict. Substantial evidence and the burden of proof. Just a couple quick words on the burden of proof. Let's refresh our recollected and understanding of the burden of proof. You need to know 2 things I always say about the burden of proof. Number 1, you have to know who has it, and you have to know what the standard is. Generally, the standard is what? Just preponderance of the evidence, more likely than not. But who has it is really a simple question. Who benefits from the affirmative of the issue? Who benefits? That is who has the burden of proof. For example, who benefits from apportionment? It's always the defendant. Who benefits from injury AOE COE? Initially, it's always the applicant. So you see how that works? The applicant on AOE COE initially has the burden of proof, but like Jake said, it switches once they meet that burden onto the defendant. It goes back and forth. So ask yourself, who has the burden of proof? Well, it's always the party that benefits from the affirmative of the issue. Just a basic rule there. Okay, I have the next one, which is the Rios case. This is a simple case. I put it in here just because it's always good to refresh our recollect as to what... This is a compensable consequence case. What happened was the applicant had an orthopedic injury and put on weight. The applicant went from, 220 to 265, and the issue was whether or not the respiratory pulmonary heart condition was a compensable consequence of the original injury. The pulmonologist said that it was due to inactivity. pretty straightforward. But let's talk about what this raises is causation of injury versus causation of disability. And I want to go through this really quickly for you. Everybody confuses causation of injury with causation of disability. And this is the way that I differentiate these two doctrines. Causation of injury, that's that threshold issue. Do we have an industrial injury? What is the standard? It's just a mere contribution of an injurious industrial event, exposure, or activity that results in disability. Then you have an industrial injury. It's just a mere contribution. That's why it's so difficult for defendants, and my clients hate this, but it's so difficult for defendants to defeat cumulative trauma claims of injury. Because if there's repetitive activity going on that has any impact on a condition, it's going to be industrial because it's just a mere contribution. That's South Coast framing. You see it cited in your materials. So that's the threshold issue at the beginning, just a mere contribution. Do we have an industrial injury, an event, activity, or exposure that's resulted in disability? Okay? Injurious industrial. What is causation of disability? Well, that's after the applicant becomes permanent stationary. That's strict legal apportionment. What caused the disability? Okay? And there you're looking at what? 4663 and potentially 4, but 4663 analysis. What caused that disability, whole person impairment and or resulting disability? So the way to differentiate these two is, are you talking about do we have an injury, or are we talking about what caused the disability? Okay? Okay, that's all I had to say about compensable consequence. Any questions? Okay, let's move on to the next case, and this is Jason's.
Yeah, I think it's Sevillano. This is a COVID case. So first off, just show of hands. How many people in the room have handled or otherwise represented somebody or dealt with a COVID claim? Okay, awesome, good. So hopefully this is all stuff we've learned by now, although I'm still in the throes of litigation on some of my COVID claims. So this case is the injured worker worked for IHSS, In-Home Support Services, and contracted COVID on or around June 26th of 2020. And that date is important because the date when someone contracts COVID or the date of injury, if you're looking at a potentially presumptive case, is important. They filed the claim was denied, ultimately went to trial on AOE-COE. Now, this was a case that is covered by one of the 3 COVID presumptions that exist. This COVID presumption first existed in the middle and latter part of 2020 as Governor Newsom's executive order, which was subsequently codified into Labor Code Section 3212.86. So that's the presumption statute that covers a very specific and limited period of time when someone contracts COVID while working out of the home at their employer's place of business between March 19th of 2020 and July 5th of 2020. So that exposure on June 26th of 20, that puts it under that first presumptive statute. There's 2 others. There's .87 and .88. One covers, is a almost but not entirely mirrors the presumption in 8.6, which is if you get COVID within 14 days of working at your employer's place of employment, it's presumed to be industrial. That covers most healthcare workers, most but not all, first responders, firefighters, public safety, things like that. And then the other third presumption, .88, is the outbreak presumption, which, as a personal aside, I argued quite strongly that that was a bad idea when that was being drafted and negotiated and written in the summer of 2020. Clearly nobody listened to me because we're stuck within the legislation. I find it to be an absolute nightmare of a presumption statute. It raises all sorts of questions about privacy, not just for the injured worker, but coworkers and other people, and employers having to keep records, maintain records, provide records. Thankfully, this is not one of those cases, so we don't have to deal with it. But if you have one of those cases, I'm sorry, they're a nightmare, or they can be. In any event, here's what happened here. The defendant was trying to rebut the presumption. And I don't know, based on the record, if the defendant agreed or stipulated that the presumption applied. I think it was a question they posed to the judge, and the judge found it did. But that goes exactly, Rich, to your point about who has the burden, right? If the injured worker's COVID-19 is presumed industrial by one of these 3 statutes, at that point, the burden shifts to the defendant. And that's a huge thing because here, the injured worker actually didn't have to prove, once the judge found it was presumptive, that's it. They can sit down and be done. Their job is over. In fact, the last presumptive case I had, I got the other side to stipulate that the presumption applies. And I thought really hard about literally doing nothing when the judge asked me if I had witnesses just say, no, Your Honor, we rest because now it is their burden to disprove that my client got COVID on the job or to rebut the presumption. In any event, this was a case about failure of proof. The defendant tried to rebut the presumption by showing that the worker's testimony was inconsistent, that they maybe didn't have the exposure that they did, but I think critically here what they lacked was any medical opinion saying that the injured worker actually more likely not got COVID somewhere other than the job exposure. And frankly, I think it would have been tough to rebut this case anyways, because this injured worker, as an in-home support service, not only lived there with or spent a lot of time with their employer, the client, if you will, but they went out and did shopping and ran groceries, so they were out in the general public as part of their job. I think it would have been virtually impossible for the defendant in this case to rebut it. But what was interesting here is the defendant, I think, was really trying to show that the injured worker was not credible. And in fact, the judge found that the worker testimony, they said, I don't believe this worker. They lack credibility. But here's what the board said, and I think this is critical, again, if you're trying to rebut COVID or other presumptive claims. The board said the relevance of the WCJ's credibility determination, while important, is attenuated by operation of the presumption statute, which serves to ease applicants' burden of proof of industrial causation. That's my point about if they've agreed to the presumption, I can just walk in and say, I win, your job to disprove it. Here, applicant qualifies for the presumption under section 3212.86, and the affirmative burden now rests with the defendant to disprove that the injury arose out of and in the course of employment. On the record before us, we are persuaded that the presumption of injury is applicable based on undisputed facts unrelated to the applicant's testimony, and that the defendant has not affirmatively rebutted the presumption. So what does it take to rebut a COVID presumption? Well, I don't know, because nobody's ever done it to me. So I'm just...
that was going to be my question.
Right, yeah.
How many, I mean, I've handled a lot. Let me ask Jake this. Have you defended successfully a claim of COVID?
I don't think we have any that we've actually gone to trial with and found non-compensable.
Okay, so here's...
We've resolved some, but... and I haven't done a whole lot of COVID cases.
I've done quite a few.
I try to avoid COVID if I can.
Yeah. Some of you may not know, but Jake had a really bad bout with, I shouldn't laugh, because it scared the hell out of me.
You can laugh now.
Anyway, but I represent Empress Healthcare, and so their facilities, there was a lot of COVID claims that came through there. And let me tell you what, I mean, the first thing I did was, before we had the presumptions, is they asked a couple of my clients, one large client and then Empress Healthcare, asked me to address whether or not COVID were defensible, COVID claims. And you might want to write this down because this is a little nostalgia. This case involved believe it or not, the Spanish flu pandemic. I don't want to say my legal research is extensive, but this is a 1918 case, and I'm going to give you the site for it. It's 183 Cal 273, and then that's 183 Cal 714, and then Cal 273, and involved the Spanish flu. And without a presumption, they were establishing liability on those cases. Here's the problem from the defendant's perspective. The applicant comes in and says, hey, I was working for you and I came down with the flu, COVID, whatever. And then they're absolutely right. Even without the presumption, the burden of proof shifts onto the defendant. And we have just an onerous task of establishing there's no way you caught it here. How do you, and this is what I told my clients, how do you establish that where the applicant has any interaction with the outside community, or there happens to be somebody that came down with COVID in the workplace? I don't know how you certainly don't rebut. Here's the fallback position on the good news is most COVID cases, I mean, I'm vaccinated and boosted and I still caught it twice. And each time it was about a week, so most people don't have residuals from it. There are exceptions, and I don't mean to make slight of it. Certainly, if you have comorbidity issues, you should be very cautious about not being vaccinated and not avoiding it. But the fallback is there's no residuals, and I find myself litigating the claim of long COVID. And as a defense attorney, I'm suspicious. I'm telling you, because long COVID, it's all subjective. There's no absolute objective findings for a diagnosis of long COVID, and I'm seeing a correlation here. I'm seeing the same correlation that I saw before we had a definitive test for the myofascial pain syndrome fibromyalgia, okay? Remember how we used to have those claims all the time? They were like, 20% of my practice was fighting the subjectives associated with the fibromyalgia, and we don't see them anymore. Okay, these were often, and I don't want to be harsh here, I don't want to offend anybody, but long COVID, I always look at the work history. I want that personnel file. I want to know how they're getting along with everybody else. And to me, that tells me whether or not it's a valid long COVID or if there's something else going on here. And so I find myself defending claims of long COVID with associated subjective complaints that can be translated into some measure of whole person impairment and or extending TD.
Right. And I didn't mean to sound so strident in my defense of COVID claims. I mean, look, the presumptions are a huge benefit to injured workers, not just the COVID presumption, and they're quite hard to rebut. But in truth, if you're going to try to rebut one, in my opinion, you need a medical opinion indicating that the injured worker more likely than not got COVID outside the workplace with specific facts to back that up. Like, for example, if the worker said, I got it at work, and the history is that their family members who they were in close contact with 2 weeks before they got COVID all had COVID, and within 4 or 5 days of their family having COVID, they got COVID, and nobody else at work got COVID, and the QME or the AME says, I think they got COVID from their family, not from the job, there you're probably going to rebut it. But if you're hoping to rebut it by simply showing, the employer had COVID workplace safety guidelines, because that's one of the things referenced in the statute about evidence that can be used to rebut, but not a medical opinion, I don't think you're going to get there. If you're going to show that the worker's testimony is unreliable, but you don't have a medical opinion, I don't think you're going to get there. So it's an uphill battle for sure to rebut it, but I think if you're going to be serious about it, you need a medical opinion that supports rebutting. And if you have a medical opinion that says it's industrial and you have the presumption, please don't go to trial in that case. And I say that I'm pending a decision on a trial in that case right now that I'm a little fired up about. So we'll see what happens.
I was just going to echo something that Richard said, that I've had several COVID cases, and even once you get over the causation threshold and you prevail on injury OECOE, if it's a long COVID case, you get into a whole different realm of issues because there's just not a lot known about long COVID. And, I've got a case where all of the diagnostics are normal, the pulmonary, the echo, everything is normal. And just extremely challenging. I'm just going to leave it at that.
Tell me this, we circle back now to discovery. Am I going to get the medical records to find out?
Here we go again.
Yeah.
Yes. Yes.
Yeah,
and you're going to have to pay 5 different QMEs to review 2,000 pages of Kaiser records, unfortunately.
Listen, I tell my clients, I have a case right now where we have, are you ready? 30,000 pages. Oh, yeah. And we're paying $40,000 a medical legal. And I tell my clients, and we have 3 specialties, and they want a 4th. And you know why they want a 4th? Because it's more money, and they want money from us, and they won't know. But I tell my client, every time we go in there, every time we want to refresh everything, every time we get a medical, some of it, the records have already been reviewed, so they're not going to be reviewed. But it's $10,000 to $30,000 a pop. And if you think that doesn't drive, if you think defendant doesn't consider that when evaluating a case for settlement, especially the large cases, we do.
Absolutely.
Yeah. Okay, now we're up to, this is Dudley's case, date of injury.
Okay, so this is also a topic I've spent a fair amount of time on, so maybe an overview. I think generally speaking, when we talk about cumulative traumas, we like to think of periods of employment, right? And if you look at the application for adjudication of claim form that the DWC uses, it calls for a period of employment from X date to X date. And if you actually read Labor Code Section 5412, we are not talking about a period of employment. Mm-hmm. We are talking about a date. We are talking about a date when disability and knowledge of an industrial injury, when those 2 elements coincide. And so if you've got a firefighter who retired in 2014 that is diagnosed with cancer in 2023, the date of injury is not cumulative trauma through December 31st of 2014 or whatever his last date was, it's the date that he was diagnosed and he became aware that he had a workers' comp claim in 2023. And so I file these claims. I file the application as, whatever, January 15th, 2023. And then in the explanation part, I put for employment up through the end of 2014 or whatever his period of employment was. Then I get all of these petitions to dismiss the application because the applicant wasn't employed in 2023. All kinds of issues come up with that. But that is because we are so accustomed to looking at cumulative traumas as a period of employment. So that's kind of the background. The case of Saavedra versus County Fresh Herbs, this is a case where the judge was struggling with what is that date? What is the date for the appropriate date of injury? And this brings back flashbacks of Western growers for you guys that have been doing workers' comp for a long time. Colfarp, there's all these cases where the courts of appeal have struggled with many of these very same issues. In this particular case, there was a specific injury on March 30th of 2016. The applicant filed a CT on 4/19/17, and then the QME saw the applicant on September 12th, 2017. So you had three possibilities here, and ultimately the judge and the appeals board found that the date of the evaluation with the QME, the September 12th, 2017 date, was the date of injury. And that was because that's when the applicant first was provided with an impairment, and at that point he clearly had knowledge. So that's when those two elements coincided. The issue here was, well, the QME didn't find the applicant permanent and stationary when he saw him, and in a supplemental report, the QME did describe impairment, and the commissioners held, well, even if the applicant is not permanent stationary, he can still have impairment, i.e. disability. So that's the date of injury case. Just as anecdotal, when I was a judge, I had a trial where the date of injury was modified or amended on the date of the MSC. It was amended on the date of trial. There was a post-trial brief amending it a third time, and then on recon they tried to amend it a fourth time. But that was a case where the applicant at trial testified that he had no idea he had an industrial injury until seeing the QME. So this case brought back some memories.
There's on the amendments subject to proof, which we hear all the time from the applicant attorneys. I'm just going to throw this out there so all the applicant attorneys are aware of this. I don't have the site with me, but there's a Court of Appeals case that holds that once the issue's been addressed, once there's been a formal order on at any level on a particular matter that's been pled, that you cannot amend subject to proof at the time of trial. And I had an applicant attorney who I respect, good guy, and he was jamming me forward to trial, and he didn't have a lot of evidence on the specific that was filed that we were trying on, but he had the QME say it was a CT, and he never amended it. Well, we had already been to court on other unrelated issues, but there had been substantive rulings. And I found a Court of Appeals case that said once that happens before the WCAB, that you have to go forward only on that claim. And because the statute of limitations might have run, he didn't file it, that CT might have been barred. Now, what did I do with all that? Do you think I did the happy dance around the courtroom? No. I did what you would expect me to do. I did a trial brief articulating everything. I gave it to him and I gave it to the judge. I didn't put it into Eames because I wanted to settle the case. And I also didn't want somebody who had made a mistake on an issue that I only came across when I researched it. I didn't want to hold him up to dry, out to dry. And we ended up settling the case for a value that was within the range of where it should have been, and we got rid of that. But be aware of that. Generally, as a general rule, you can amend it subject to proof, right? But there's an exception to that where you actually have a prior ruling from that court on any issue, and then you're only going forward on that specific date of injury. And where you haven't amended it with the CT, where it's a specific, that limited fact, that CT may be barred by the statute of limitations because he had medical evidence of the CT for 3 years. He just never did it. It's oversight.
Right.
But
Well, I would just say as a general pleading, it really helps to put some thought into it when you open up the case.
well, can I ask you this? Why would, if I know you're going to say what you're going to say Benson, but why, if I was an applicant attorney and I have an employee of long duration, why wouldn't I always include a CT with my specific? Other than Benson.
Benson?
Okay, other than Benson.
Well, I guess it depends on what the facts are, right? I don't file a CT every time I file a specific. It just all depends on what the facts are, and because of Benson, I think you need to be careful.
We used to. I mean, if you have a case, if I got somebody and they're like, oh, I had an injury back in '97, and I go in EAMS, there's like 3 or 4 EAMS files with, like August of '97 and October of '97 and June of '97. I'm like, oh yeah, they because it's just what you did, because it didn't matter, because they were all going to be the same body parts, all going to be the same employer, all going to be P&S at the same time. It's going to be one award. Who cares? Now with Benson, Jesus, like it's. I get upset when I see a doctor go, yeah, it's 90% specific and 10% CT. Oh, I gotta, it's just. And then what happened? And then you file the CT, and defense says, oh, it's a new claim. We get a new QME. I mean, at that point, it's like, because of all the fun procedural rules that maybe we will and won't talk about, right? Like it creates so many more problems these days than it used to. I don't know about you, Dudley. That's why I don't do it.
I totally agree.
How do you guys feel about the defense attorney who creates a CT and then says, I want a new medical legal? Yeah.
It just, yeah.
I mean,
Here's a statute question, right? What if the medical records show that there's an evidence of a CT and the employer has those vis-a-vis their carrier, and they don't provide the worker with a claim form? Is the statute not told at that point?
I would think it would be told, don't you?
Yeah,
because
would be.
that's your case, that there's a duty to provide that claim form, and it's going to be told until, yeah. Okay, let's talk about the next one. So the counterpart, why do dates of injury matter? Well, they matter for 2 reasons, cumulative trauma, as I see it. Number 1, who's the dependent, what are the benefits, statute of limitations, and that's the classic 5412. There, you have the following elements. You have to have an injurious industrial exposure event activity, resulting disability, and knowledge or reason to know the cause and effect relationship between the two. That is the date of injury. What's the date of injury when it comes to apportionment of liability as between co-defendants? What are we talking about here? We're talking about contribution. Who's on the risk for the benefits being provided? And that's what the next case discusses for us. In Madrigan, this is a cumulative trauma through 4 pled originally as through 4/18/17. The applicant, however, continued to work, and this is a critical fact, he continued to work through 5/15/18 without any evidence of physical limitations, restrictions, job modifications, disability, or otherwise. He lost no time from work. So at this point, what do we have? We have arguably injurious industrial exposure without any disability. So we don't have a date of injury, do we? We can't, because 2 of the 3 haven't occurred yet. Then he receives his first treatment on 4/18/17. Is treatment in and of itself sufficient to establish disability for the purpose of establishing date of injury for cumulative trauma? Let me see if I can say that faster. Is medical treatment sufficient? They say that you speak fast when you're... is it a sign of high IQ or low IQ? I don't know.
I hope it's high IQ.
I hope it is too. Anyway, so the question is this: is medical treatment sufficient to establish disability? How many people say medical treatment will establish disability?
Yes.
Oh, shame on you.
No.
Every time? Every time.
When it suits my needs.
Okay, you can argue that. Okay, here, it can establish disability.
That's my point.
Okay, it can, but it generally doesn't. You're looking for medical treatment that supports your conclusion, a finding, that there's TD or PD. Lost time from work, temporary disability, permanent disability. Right. Okay? So as a general rule, medical treatment by itself does not establish. And that's what they held here. That the fact that he had medical treatment doesn't establish a date of injury. So what's the date of injury? Well, it's when the QME examined the applicant, and that occurred on 5/15/18. That appears to be the last date of work. That ended the injurious industrial exposure, right? Okay, that ended the CT because now he's no longer working. He goes in, has his PQME examination, and tenders his resignation the next day. The PQME finds him permanent and stationary and ascribes a level of disability. He ends work. So here's the issue. His last date of work is the PQME examination. I don't know how that works, but evidently that's what the facts were in this case, of 5/15/18. He had originally filed a CT through 4/18/17, about a year prior. We had two insurance carriers, ICW, their coverage ended 3/13/17, which would have just about swallowed up the originally pled cumulative trauma. Hartford took over on 3/14/17. The injurious exposure continued through 5/15/18. So think about what you have to have. You have to have the concurrence of what? Injurious industrial exposure activity or event. You have to have disability, and you have to have knowledge or reason to know. Well, the knowledge or reason to know and the disability appear to have occurred on the same date, which was the date of the examination, ironically the last date of employment, and also the last date of injurious exposure of 5/15/18. So who's responsible? Under 5500.5, it rolls in the last year of injurious exposure. ICW is out, and they rolled it off onto the subsequent carrier. Now, I want you to, in this box here, I want to read this to you. This is from lecture notes. This is what I say. I write this. The date of industrial cumulative trauma injury for determination of the applicant's entitlement to benefits, and I put in parentheses, date of injury for statute of limitations, indemnity rates, dependency status, requires the concurrence of 1, injurious industrial activity, events or exposure, which 2, result in disability, and 3, knowledge or reason to know that there's a cause and effect relationship between the injurious industrial activity and the resulting disability. The date of cumulative trauma is important for the statute of limitations under Labor Code Section 5405, the rate of indemnity, dependency status, and timeliness of a petition to reopen. However, while the date of injury pursuant to 5412 is controlling on the applicant's entitlement to benefits, it's not determinative on the issue of apportionment of liability for as between co-defendants. Okay, so now we're dividing it. So what is the analysis there? The first step in the analysis is to determine the date of CT injury. We have that up above. The concurrence of injurious industrial exposure, 2, disability, and 3, knowledge or reason to know of a cause and effect relationship. Second step, did the last date of injurious exposure occur before or after the date of injury? If the last date of injurious exposure was after, that's going to be the last year of injurious exposure. That's going to be under 5500. Who's responsible? That's only fair, isn't it? If 5500.5 says it rolls into the last year of injurious exposure, it's going to be that last year when it ends that the carrier is going to be responsible. And that's what this case holds. Okay? Any questions other than could you slow down?
You know, a lot of the CT claim, the issues involving CT claims arise out of cases involving SIGA, because they're constantly looking to move the date onto somebody else. Because if you have one day of that, then you're in for the whole thing.
Now, the next case is I kicked over to Jake, and that's because everybody seems to have a field of expertise up here except for me. Jake knows professional athlete cases and jurisdiction, and let me tell you, this is a real quagmire. Every time I have to put one of these cases in my book, literally, it's hours to re-review everything, how it works, what's going on, and try to come to a conclusion as to what they're actually saying. So,
Well, and they're a lot simpler than they used to be.
yeah, well, okay, for you, Jake.
Well, I mean, I'm going to actually go through these fairly quickly because the first case, the Hansel case, the significance of it has to do with the interpretations under Labor Code Section 3600, and there's some different provisions in that in terms of when you have California jurisdiction and when you have a deferral of California jurisdiction. And in this case, the applicant had a lengthy career as a baseball player. Almost all of his time as a baseball player was outside the state of California. And in looking in terms of the time that he did not meet the criteria under the sections that passed, I think in 2013, that limited exposure for professional sport franchises for players. You had to have like at least 2 years of play for a California team out of 7. You had to, or 20% of your entire career had to be spent for a California team playing in California games. You get to include all of your appearances in California. If you don't meet those criteria, you could be excluded from getting workers' compensation benefits. But there's also the provision that talks about if you are California resident, if you're hired in the state of California, and what the court said in Hansel is The specific language talking about being hired in the state of California and being a resident of the state of California is more important than the other language excluding cases. That's intended to eliminate people who have very tenuous connections with the state of California. What was happening prior to 2013 is you would have a player who played for Miami Dolphins, Arizona, whoever the hell Arizona's team is, Cardinals, and maybe Tampa Buccaneers, but they came to California 3 times in a 12-year career. They'd collect benefits in those other states for injuries and then come to California, file a cumulative trauma claim, and get an unapportioned award of permanent disability medical care, settle the case for $250,000. And that was happening on a routine basis. There were law firms that were advertising all over the country to get people to come and file workers' compensation claims, state of California. The changes to 3600, specifically C and D, were specifically intended to eliminate that, but they were not intended to eliminate all of those people who had contracts of hire in the state of California, where they signed their contract in California, where their agent was in California, and especially where they lived in California. So in terms of jurisdiction, you're not going to be able to eliminate somebody who otherwise would have a legitimate claim as being a California employee, having worked for or played with a team under a California contract of hire, because they don't meet the other criteria in that statute. The second case, Oliver, is one where the applicant was diagnosed tentatively with the chronic traumatic encephalopathy, which is the CTE. It's a diagnosis which can really only be confirmed on death and on autopsy. But the diagnosis, the neurologic evidence was that this gentleman probably had CTE. The permanent disability rating was 98% on the neurologic end of the case. The applicant attorney argued, you should find my client to be temporarily totally disabled until death, rather than get a finding of permanent disability at 98%, because what he really wanted to do was have the potential for getting a permanent total disability at some point. What the court said is, you don't really need to go through that. We're going to consider this type of case, the chronic traumatic encephalopathy, as similar to those chronic diseases under the Jackson case, the asbestosis, and you can get a finding of tentative permanent disability, reserving jurisdiction indefinitely to redetermine permanent disability if the applicant gets worse. And this one meets that criteria for those kind of cases. They've also applied that same kind of analysis to some other internal medicine cases that involve chronic progressive diseases. Valley fever is one of the exceptions that's been applied to. They generally will not apply it to orthopedic cases. So you look at the Ruffin case where an applicant attorney argued that his client's knee condition was a progressive long-term condition. They said, no, that's not what we're looking at. But internal medicine issues appear to be one of the ones where you have that particular option.
So, in citizen progressive, I think is an extremely important legal concept. I deal with it a lot with my presumptive cancer cases, and some of those folks are in remission, and so they may be pretty functional at that time, but they have such a cancer that'll likely come back and will create a very severe disability. So I deal with this issue quite often, and it's just very important.
Okay, here's what we're going to do. I'm looking out there. Everybody looks bright-eyed and bushy-tailed. So we're going to go ahead and take our break right now, and we're going to keep going because I want to get through permanent disability. There's a couple of really important permanent disability cases dealing with the 4661 versus 4660, and we need to get through those cases. So let's go ahead and take a break, get some coffee, stand up, jump around. We'll be back. Okay, let's go ahead and return to our seats. We're going to get started. What we're going to do is delay the next panel. I really want to get through the next few cases into the PD cases before we leave this session.
Hey, Rich, can I correct one thing I said?
Sure. Evidently, we have errata sheet coming out vocally, verbally.
Well, I just wanted to make one quick correction on something I said initially. I think I might have said 50% of the benefit delayed on this new penalty provision applicable to the denial of presumptive cases. It's actually 5 times the value of the benefit delayed or denied, or up to $50,000. So the max penalty is $50,000, but it's 5 times the benefit. And if there's any 4850 or full salary benefit that's delayed in one of those claims, it's very easy to get to the $50,000. So I had misspoke earlier, and I just wanted to correct that.
Okay, we finished the jurisdictional cases. We've got a couple of medical treatment cases that are of some import, so let's go through those. The next case is Jason's.
Yeah, I think it's Tikhonov, if I'm saying that wrong, sorry. So this was a case where the injured worker suffered a pretty serious catastrophic injury, and that the parties stipulated that the worker was 100% disabled. Then fast forward, in February of 2020, they somehow a registered nurse prepared an in-home patient care evaluation report to evaluate the home care needs of the applicant, and concluded that the applicant needed a variety of home care needs on an indefinite and ongoing basis. And then an RFA was issued like in December of 2020. Now, I was looking at this case and trying to understand how it is that a nurse says the person needs home care in the first part of the year and there's not an RFA done until the latter part of the year. I can't explain why that happened other than that's apparently what happened. The RFA issued, it went to UR denied it. They appealed to IMR upheld it. The applicant's attorney then appealed the IMR decision and made a couple of arguments which I think were interesting, and I understand why the applicant's attorney did this. Look, if you have somebody who's totally disabled and they need home care, that's a serious thing. And I could take a moment to rant about why UR would possibly deny home care when an RN has said they need it, but that's simply how UR works these days. I know. Thank you. Those of you who've been making faces, thank you. Right? Okay. In any event, so the applicant attorney made a couple of arguments. One, they argued that the reviewer used the wrong version of the medical treatment utilization schedule, and that they should have used a prior version from 2016 as opposed to the most current version. And secondly, they argued that the defendant had been on notice for a number of years that this worker needed home care, and that the defendant had failed to perform their duty to investigate, and because they had failed to perform that duty, they had essentially waived their right to submit the issue to UR. On appeal, the board upheld the denial. Basically, their conclusion was this. First, what the injured worker was really challenging here was the question of medical necessity. And the board said, look, under Stevens and the 2013 reforms, if it's a question of medical necessity, your only remedy is UR and IMR. And if IMR upholds it, that's the end of it. We, the board, have no jurisdiction to look behind the veil, so to speak, and understand the how and the why of that decision. If it's a purely medical decision, there's nothing we can do about that. They also, however, said that the regulations require that UR and IMR reviewers use the most current version of the MTUS, which is what the reviewer had done here, so they found no fault with that. And then they looked at the facts and the history of the case, and they said despite applicant's attorney's argument that the defendant had been on notice for some years, they said, look, there were all these reports, and none of those reports talked about home care or the worker needed home care. And they also said that while I think they didn't say this, my sense is they appreciated the argument. They did distinguish between an employer's duty to investigate, like when a claim is initially filed, and what duty an employer has to investigate requests for medical treatment. And they basically said, look, what you really need is an RFA, and that didn't happen until December of 2020. That went through the UR and the IMR process. It was all done appropriately. There was no question of timeliness. I think the injured worker even agreed that all the decisions were timely. So to me, it's an interesting argument, but ultimately it failed because under Stevens, the board has no jurisdiction to address questions of medical necessity, and that's really what it was here.
The next case is Dudley's. This is in-facility termination of care.
So yeah, this case dealt with an electrician who had a traumatic brain injury. He was, the primary treating physician recommended inpatient treatment, at least an initial program with inpatient treatment. The RFA was issued, UR certified the initial program. Then subsequently 2 RFAs and 2 URs extended the inpatient treatment. Ultimately, RFA was submitted, and the UR denied it on the grounds that there was no meaningful improvement after the initial inpatient program. Citing the Patterson case, the judge basically refused to follow the UR determination denying the inpatient facility treatment, and basically said under Patterson, the defendant had to show some change of circumstances before being allowed to submit the issue back through utilization review. The judge found that there was no change of circumstances, and that was upheld on recon. Defendant argued that the lack of improvement after the initial program, that in itself was a change of circumstance. That, in other words, had the initial program worked, there would have been improvement. That would have justified ongoing care. Since there was a lack of improvement, that was a change of circumstance. The commissioners rejected that argument, which I thought was fairly persuasive, but be that as it may, they denied that. And again, there's a long line of cases where the commissioners uphold inpatient treatment, citing Patterson, and this would be one of them.
Okay, let me just revisit Patterson really quick. Patterson was a case involving a nurse case manager. The issue was, or what they held was, the provisions of a nurse case manager as a form of medical treatment under Labor Code Section 4600, absent a change of circumstances or conditions showing that the services are no longer medically necessary. The defendant may not unilaterally terminate the nurse case manager's involvement. Number three, the issue of unilateral termination by defendant of the nurse case manager involvement is a proper issue for expedited hearing pursuant to 5502B1. And last, the applicant is not required to obtain an RFA from the PTP for defendant to submit to the UR where the nurse case manager has previously been involved or authorized. This is a case that comes up in my practice with some frequency. I have one right now. What happened was it's a closed head injury, and that's important, I think, in Dudley's case. It was a significant injury. It was a closed head. I have one right now that came in where we have a UR denial, not of in facility, but in facility they want to do a step down care. The argument is they no longer require that measure of treatment. And of course, my client right now is paying $30,000 a month on this case. And they send it to me and they say, what do we do? Now, the first thing I did was I did an IFR, initial file review, and I cited Patterson. And I said, we're not going to terminate because we're not there. This is what we're going to do. We're going to raise our objection. We're going to assert the UR determination. We're going to let them go to IMR if they want to. But we are going to attempt to negotiate a resolution. We're going to pay the facility on a month-to-month, and we're going to threaten a step down. Now, another fact involved in this case is there was also a $12 million civil settlement, and then my client received some of that money by way of subrogation, and then an ongoing medical obligation. So this is the way that what I told and Jake and I share this client. This is what I told my client. Let's do a little face-to-face time with this counsel for applicant. Let's do some present value analysis. Let's see if we can't settle this future in facility. Now, we have an MSA in there. Of course, the MSA does not include in facility treatment, so the MSA is something we can live with because his ongoing care is pretty much stationary. But threaten the step down facility for the purpose of reducing our potential liability and the value of the case. Do a present value analysis. The counter argument on the applicant side to be anticipated is, well, what about inflation? These costs are going up. You want to talk about present value analysis. But that's what's on the table, and I haven't negotiated a settlement, but I think counsel for applicants is listening to what I have to say. Because his client has already received a large settlement in the civil side, there should be sufficient monies and motivation on all parties to wrap that up, and I'll see what happens. But we see this over and over. But what I didn't do is what the crazy defense attorneys say. Oh, let's go ahead and cut. Let's go ahead and cut. We're not going to pay the bill anymore. I mean, those are the defense attorneys that when you send them your file, all they're doing is being yes men, and they don't want to tell you the truth because the judges are not going to, they're going to bend over backwards to find that there's no change in circumstances. Okay. what I'd like to do is skip ahead because we need to get to the next panel. And I want to skip ahead to the disability because we have a couple of cases that are addressing whether or not 4660, 4660.1 should be held the same way. This is what I want everybody to understand. Now I think it's pretty clear, and the panelists can tell me if they disagree, but the ways in which to establish on a post-1-1 on or after 1-1-13 date of injury are the following. You have the standard rating and the standard method chapter table. Here, the objective findings are critical because that formulates the diagnosis and allows the doctor to go to the proper method chapter table within the AMA guides. That's the standard rating. Then we have Almaraz-Guzman. Almaraz-Guzman says, okay, doctor, tell us what the standard rating is based on the objective findings and the diagnosis. Then tell us whether or not that standard rating is accurate, i.e., is it complete? And if it is, you're done. If it's not, tell us why it's not, and you're free to use, by way of an analogy, an alternative rating, okay? Then we have this out there, traditionally, we've had the Guzman VR, pre-1113 and post-1113. We have this 4062B and VR evidence, kind of a LaBeouf argument. And those are the methods in which we establish, and then we have 4662A, which are the presumptive 100%. Now understand, 4662 only applies to 100% cases. But the question in my mind still, even after these cases, is whether or not you can use VR evidence to establish rateable disability, not going to the standard rating, not going to Almaraz-Guzman, and on a post-1113. And that's what these cases that I've cited here address. The first one is the Wilson case, and that's Dudley's case.
So in Wilson, you have an applicant with CRPS. Apportionment's not an issue because the AME basically followed HIKITA, which Rich just mentioned, and said basically 100% of the CRPS was related to a surgical procedure. The AME further said basically, hey, this applicant's precluded from work, okay? The AME did recommend a work capacity evaluation as well as a vocational rehabilitation assessment. So when the case goes to trial, the judge basically awards applicant 87% and does not follow the AME's inability to work language, saying that really that's more of a vocational rehabilitation issue. And so the case goes up on recon, and the question really was whether that constitutes a vocational opinion or a medical opinion. And historically, I was always of the belief that an AME or a medical legal doctor could say permanent total disability. That at some point that is a medical conclusion, that the AME is entitled to say this person could never meaningfully work again. And that in those cases I may not even have to get vocational rehabilitation evidence. This case would sort of argue otherwise. It says basically that opinion, well, let me just read you. It says where the agreed medical evaluator imposed only limited work restrictions, which vocational experts arguably did not believe precluded applicant from meaningful employment. So basically, they're saying that there was a conflict in the AME's opinion of inability to work and what the VR experts had to say. At the end of the day, they felt that the AME on the vocational issue does not constitute substantial evidence and upheld the award of 87% permanent disability.
And I don't want to mislead the audience with the way in which I brief this case. This is a substantial evidence burden of proof case. I'm not, and I agree with what Dudley's saying. I think a physician may be able to address total disability. I don't think that's a safe harbor for medical legal doctors. However, I think that they can, but they have to do it in a way that constitutes substantial evidence. And right. I think that's what they thought here, that it did not.
Right. So I would say that when you're looking at a catastrophic case, the doctor's work restrictions, no matter what road you end up going down to establish 100% permanent total disability, the restrictions that the doctor describes become extremely important. Okay, so I think had the doctor fleshed out the restrictions, part-time work, missing, several days a month due to pain levels, having to take naps in the middle of the day. Had the actual work restrictions been fleshed out in more detail here, this would have been an easier case for the commissioners. Kind of like that case that was discussed earlier with the 64% orthopedic and the 99% headache. You know, at some point you're looking at somebody, and even as a trial judge I did this, like realistically, is this person going to work again? And the work restrictions are critical to coming to that assessment.
No, in the post-Fitzpatrick world, I think it gets to be much more difficult for a medical legal evaluator to offer an opinion on permanent total disability. And I think you'll see Fitzpatrick cited in a lot of these cases, where they basically said that's really outside the doctor's area of expertise. You don't get there with that. You look at Fitzpatrick, where you had a combined, I think 78% combined with a 72%, and everybody looked at, I'm sure everybody looked at it and said, this is a 100% case. Came out to 99, and board and the Court of Appeals said, you just can't get there with the doctor's opinion. You need to, if you're going to rebut the schedule, you have to rebut the schedule with other kind of evidence. So I think it gets to be very difficult. I mean, a doctor can describe really severe restrictions. I think you need to get somebody else to flesh out that.
Yeah, you know, this is kind of analogous to, it's not directly on point, but remember the old Blackledge case that kind of instructed the board who did what and why?
That's a great
That
case.
case said that it's the judges, well, it's the evaluator to describe the PD, it's the judges to award the PD, it's the rater to rate the PD, and they all have their separate roles. Well, I think that's what applies here. I think doctors can go ahead and say the obvious, but it may or may not be constitutes substantial evidence for the purpose of 100% award. The better way is always to get vocational evidence and let the stay within your, in other words, stay within your lane, doctors and VR experts. Let the doctor describe and this is what I've said for years, let the doctor describe the level of physical limitations and restrictions. Let the vocational expert then take those physical limitations and restrictions and apply that through VR evidence as to whether or not the applicant has a higher level or is 100% disabled. I think that's...
Yeah, just to counter that really quickly, though, the problem with the vocational evidence is, one, it's expensive, and it's coming out of my pocket, and ultimately I'll get reimbursed for it, but there's a cost to my practice in getting vocational expert evidence, but more significantly, it's going to cause a huge delay in that case. At least the VR experts that I use will take several months to get me their initial report. Then the defense attorney wants to take my expert's deposition and wants to, then they're going to hire their expert. Then my report has to be sent to their expert. Their expert has to be sent to my expert. It's a huge delay in the case. And when I have somebody with, a catastrophic injury, quadriplegia, whatever you want to say, and I have to go down the vocational rehabilitation expert route, that's a bummer. I do, but it creates a huge delay in those cases, which to me are obviously 100%, and which I believe the medical evaluator should have the prerogative, to say, hey, this person's just that disabled. But as Jake said, I'm not sure after Fitzpatrick the medical evaluator really can do that.
Yeah, this is going to cause everybody to think less of me with what I'm about to say. I don't know if that's possible. Thanks, Jake. Jake said, I don't think that's possible, or I won't, or whatever. No, here's the deal. If you think I don't know that VRX evidence is going to delay the case and that isn't a bargaining chip, you're wrong. So that's why I asked Jake earlier, do you ever use a VR expert to establish? Because there's a lot of arguments that VR experts on the defense side can make regarding this is why this person can work with technology now. And so I'm not, if I have the right VR expert, I'm really not that concerned, other than the cost. Now, on the and it's going to delay the case, I know. On the applicant's side, here's my question, and I never see this. Why is it that as soon as you need a VR expert, why is it that you're not filing a petition for costs, anticipating, subject to reasonableness? I mean, and get an order. My client, I know no way to avoid that cost. Do you, Jake?
I think you cannot get an order prior, in part because the criteria for evaluating whether it's reimbursable is whether it is capable of affecting the decision.
Right.
And doesn't have to be something the judge would necessarily rely upon, but there's a threshold that you have to meet in order for it to be reimbursable, and you can't meet that threshold until you have the report. And in fact, you can't meet that threshold until you go to trial.
But
Now,
if
I will frequently recommend to my clients that they reimburse if I think it looks legitimate and it's something, okay, I look at this case, said, yeah, I expected this. I'm not going to hardball the applicant attorney on that. If I look at it and say, this is somebody who's really trying to milk the case, I might object to it and say, no, I'm going to try the Hardy issue and see if I can get more, finding that it's not compensable. But I would say 95% of the time it's going to end up being reimbursed.
I'll throw this out to the panel. Do we want to jump over and take the 4060 cases, or let's just take them in order? You're up next, Jason, on the Ryan case?
Yeah, this case has everything. It has 4662, it has rebuttal, it has VR evidence, it has apportionment, it has Benson, it's got all those things. The basic facts are this. The injured worker... What's this?
It's a kind of a short write-up for all that stuff.
Right, I know. I'm like, oh, I started looking. There's a lot here. Yeah. The injured worker was a correctional officer, correctional captain for Department of Corrections, and had 4 different claims. A CT ending in December 2015, specific injuries in May of 2015, July of 2011, and November of 2012 to multiple body parts, neck, spine, back, sleep, heart, cardiovascular, pulmonary embolism, GI, et cetera, et cetera. Lots and lots and lots of injuries. And the issue is really, is this worker total, and is there apportionment? There was an AME who found the worker to be totally disabled solely due to the last in time December 2015 injury, which I think is a critical fact here. The doctor also found that the disability resulting from the various injuries was inextricably intertwined, thus invoking the Benson exception, so the worker's award wasn't subject to apportionment between those different dates of injury. There also was vocational evidence, and the vocational evaluator said this person's total. That went back to the AME. The AME looked at it, said yes, it's total. Went to trial. The worker was awarded 100%. On appeal, the appeals board upheld the award of 100%. One of the arguments defendant made is they raised Fitzpatrick. They said, hey, wait a minute, like the judge here cited 4662B, in accordance with the fact, and that's improper. And the board very correctly, in my opinion, noted that Fitzpatrick was a pre-1113 case, which meant permanent disability was governed by Labor Code Section 4660. But for injuries on or after 1113, of course, PD is governed by Section 4660.1. And they specifically pointed to language in 4660.1 subsection G, which says, nothing in this section shall preclude a finding of permanent total disability in accordance with Section 4662, which does not exist in Labor Code Section 4660, which is what Fitzpatrick said, that you can't get to total disability simply using 4662B. Now, I don't think the court here is saying that a doctor can simply say somebody's total under 4662B and you're going to walk into court and get an award of total disability. It still has to be based on substantial medical evidence. And they had that here, and that you had an agreed medical evaluator who not only assigned impairment but gave significant and detailed work restrictions, and then a vocational evaluator who used those work restrictions to provide an opinion that the worker was totally disabled, and that in turn was then also supported by the AME. So that, I think, is the substantial medical piece. Interestingly here, the court notes in distinguishing this case from Fitzpatrick that there was vocational evidence here and not in Fitzpatrick. And I didn't handle Fitzpatrick, but a local attorney in town did here. And my understanding that they actually did have a voc evaluator in Fitzpatrick, but it wasn't something that was relied upon, or the judge found it not substantial evidence. So I'm not sure that that distinction is quite accurate based on the facts. But in any event, I don't think that you as a defense attorney can simply walk in and say, ooh, Fitzpatrick for a post-1113 case, and prevent us from trying to get to 100% using that avenue.
Yeah, that was Ron Metzinger's case, correct?
Right.
And we had a really good judge on that, Timken. And when I originally read it, I kind of thought that he could have gone a couple of different ways to find that 100%. And I don't know where that case ultimately ended up, but I understood that there was VR evidence, and
There was an
rebutted.
expert. It was not relied upon by the judge.
Yeah.
though.
Yeah.
Interestingly, so this Ryan case, the applicant's counsel here is Metzinger and Associates. I think it's also Ron's firm, but I can't say that for certain because it's a Van Nuys case, which would surprise me for Ron or his firm to take a case down south, but who knows? So maybe it's a different Metzinger and Associates. I don't know. I haven't talked to him about this case, but how ironic that he has 2 Fitzpatrick cases on either side. But so that you don't think this is purely an applicant's attorney's case, while upholding the award of total disability, the board remanded for the trial judge to address apportionment under 4663 because the AME did state that there was some apportionment to non-industrial factors as part of the overall disability, and they did not follow the trial judge's opinion, who essentially rejected the non-industrial apportionment.
Okay, the next one's a kite decision. That goes to Jake.
But it's actually, there's some multiple issues here. This is a case where the applicant filed the cumulative trauma involving knees, lumbar spine, cervical spine, wrist, also ears for hearing, and a skin cancer case. The original finding by the trial judge was a 90% award based on 85% for all of the orthopedic, 23% for the skin cancer, and 17% for the hearing disability. The applicant claimed that the case should have rated to 100% and that the disability should have been added and not combined. There were multiple depositions of various doctors in the case. For instance, the hearing doctor testified and reported on multiple occasions in terms of whether the hearing loss should be added or combined with the orthopedic disability, and he gave multiple opinions on it. At one point saying, no, it shouldn't, and then saying, well, there's really no overlap, maybe they should be added, and then he's saying, well, there's no overlap, maybe they should be combined, ultimately coming down on the side of they should be combined. The orthopedic AME opined that for the bilateral lower extremities and for the bilateral upper extremities, those impairments should be added under kite and then combined with all the other impairments, that you don't add up everything, you only add up those parts that are bilateral extremity impairments. The board did something interesting with this case. One of the things they said is the skin cancer is really a separate injury. And they relied upon the testimony of the doctor in the skin cancer case, who said, I don't think this has anything to do with the applicant's orthopedic injury or his hearing loss. This is a separate kind of exposure. It's due to sun exposure. It's not due to work activity. It's certainly sun exposure at work. I'm finding it industrial, but it's really separate. And the board took that language and said the skin cancer is a separate case. It's not part of that same cumulative trauma, even though it may involve the same period of time in terms of employment, and said, we're setting this back down so that the cancer case has to be separated out, a new claim pursued for it. But I can't figure out is why they didn't do the same thing for the hearing loss. Because to me, the hearing loss is also a separate kind of exposure and a separate claim, but they actually ended up giving an overall 87% for the orthopedic and the hearing loss combined, sent it back down. And this is also one of the cases where you can't get to kite simply by arguing it. You have to have evidence on it. You can't walk into the trial judge and say, you have the discretion to add these, you don't have to combine them. The trial judge does not have that discretion. That has to be a decision based upon substantial medical evidence, and he must have evidence on it.
And look, so many of these cases say exactly that. They say it's one thing for a doctor to conclude X, Y, or Z. It's another thing for the doctor to explain X, Y, or Z. So just because a doctor says you should add or combine, or just because a doctor concludes that there's X% non-industrial apportionment, if the doctor has not explained him or herself why that conclusion follows the facts and application of law, I don't think it's going to be followed. Whether it's for you or it's for me, it's anything. I mean, it's burden of proof, but again and again and again.
They're much more likely to follow it if it's kite than apportionment.
Because the CVC is a bunch of nonsense, man. Come on.
I want everybody to make sure that they understand that. I'm going to ask Jake to go through that again, because when I read this decision, I think it has pretty significant implications on defending a case, that it's not the period of exposure, but it's the type or kind of exposure. Go through that one more time, because that's another way to reduce the PD award with a separate rating.
Well, particularly for cases like Dudley's clients,
They're,
where you will get
and they're all,
orthopedic.
the applicant attorneys here are all shaking their
object
heads.
to this conversation.
I
think we should move on.
We see a lot of sort of end of career cases that throw everything into the mix. And I think this is one of the cases where you have an argument. And you probably need to get some medical evidence on it, because they got that medical evidence for the skin case. Nobody apparently asked the hearing doctor about that. But asking him, he might very well say, yeah, well, this is really completely separate exposure from what causes his orthopedic complaints and completely separate exposure from what caused his skin cancer. This is really different. And then you'd have the evidence to say this should be a separate claim. And I remember I used to, years ago, I did a lot of work involving asbestos cases. Almost all of those people were retired pipe fitters, steam fitters, construction carpenters. Every one of them had a hearing loss case also. And we'd always file the hearing loss along with the pulmonary case and get combined ratings for them. They probably should have been separate cases.
Well, hold on. So remember, Bradley's a panel decision, right?
That's true, it is.
There are panel decisions finding opposites. So one in particular, it's Brothers via CAL FIRE, or State, Department of Forestry, CAL FIRE. Brothers v. CAL FIRE, 2019, Cal Work Comp PD Lexus 394. Again, 2019, the unwieldy site, God bless them, that Lexus uses for their panel decisions, Cal Work Comp PD Lexus. 2019, 394. So 2019, 394, where a firefighter who had accumulative trauma for orthopedic injuries and cardiovascular went to trial and was awarded 2 separate awards because the judge found that there were, even though it was one period of cumulative trauma, there were 2 distinct mechanisms of injury. The board reversed that and said, no, it's one overall CT, it's one overall injury, it's one overall award. Now, that's also a panel decision, not binding, but my point is, as much as Bradley makes Dudley and I cringe, it's just a panel decision, and there are decisions going the opposite direction. So I think this is an area where it's probably going to be the full Lawyers Employment Act for quite some time.
It may be the distinction, because I haven't read the Brothers case, but the distinction may be they didn't present medical evidence to say that it's separate. The judge made the decision on his own.
Right. So I have a case where it's kidney cancer, heart, skin cancer.
We're not here to hear about
So the bottom line is, so the defense attorney, this is ongoing. He is basically taking this case and he's saying that there's different mechanisms of injury, so we're dealing with different cumulative traumas. And then he's also looking at 5412, which talked about earlier, and saying, well, for the heart, he was diagnosed here and learned of the injury there. So he's arguing, the opposing counsel, 4 different injuries, of 50% each, and I'm at 100% because I'm combining them all. So this is really. It really renders havoc in a case. But my response is a cumulative trauma is a cumulative trauma. Work exposure is work exposure. I think it gets to be a bit artificial when you try to break it apart like this.
And Jake, to your point, in Brothers, there was medical evidence from the orthopedic and the internal medicine evaluators saying that they were in fact separate and distinct mechanisms of injury and exposure. And the board basically said, legally, here's why that's wrong. And they cited a bunch of cases to support their conclusion. But
they're clearly wrong, though.
well, clearly. So
they clearly rethought that issue.
Okay, I'm going to take the last 2 cases. I'm going to take them really quick, and then we're going to start our next. The Scott case just stands for the proposition that 4662A provides a mechanism for establishing 100% awards of disability. Okay, the Green case stands for the proposition that where you have distinct and separate injuries with no overlap with distinct parts of body, that 100% award is possible. Okay, let's go ahead and take 5 minutes, because we're honestly, we're way beyond where we should be. And then we'll reconvene here with our final panel. Okay, thank you.
Current Issues Workers' Compensation Conference is trademarked and copyrighted with all rights reserved and is the property of the law offices of Richard L. Montalbo. All duplication, reproduction, or use of this video without the express written consent of the law offices of Richard L. Montalbo is expressly prohibited. The CompCalc is trademarked and copyrighted with all rights reserved and is the property of Matrix Document Imaging. All use or likeness of the phrase or word CompCalc, or duplication, reproduction, or use of this application without the express written consent of Matrix Document Imaging is prohibited. It is not the intent of the law office of Richard L. Montalbo to create an attorney-client relationship, nor provide legal advice to the user of the CompCalc. All users of the CompCalc are instructed to contact a competent workers' compensation attorney and/or the Disability Evaluation Unit to confirm all calculations and data provided by the CompCalc. The CompCalc is available for purchase with the express consent of Matrix Document Imaging at the Apple App Store, Google Play Store, and at the Microsoft Store, or available on the Internet at the Matrix Document Imaging at legalrecords.us.